mic off करनी Thank you. No, this is fine. I'll be using this one. We'll begin. Start. Should I start? Good evening, everyone. I, Angela Gill, sign in as your host for today's evening, and it gives me immense pleasure and honor to welcome each one of you to this event, Indian IBC Story. Today, we have gathered here at this special conference for an insightful discussion on corporate insolvency and bankruptcy laws in India. The notable experts present here today at the event will share their expertise in the IBC space, given that this area is rapidly progressing with time. Dear guest, I welcome you all to be a part of this informative event to witness thought leaders from the legal fraternity and subject matter experts engaging in dynamic sessions today. Also, I would like to extend my gratitude and thank each one of you for your wonderful presence here and making time from your busy schedule and being here at this event. A big thanks to all of you. So, without any further ado, let's take a step ahead and witness the grand opening of this event by a very dynamic personality, Mr. Zulfikar Memon. Let me have the honor to introduce him. So before that, I would like everyone to please put your hands together as I welcome Mr. Zulfikar Memon. Mr. Zulfikar Memon is the ICC chairman of the Western region and MZM Legal LLP's founder and managing partner. Mr. Zulfikar Memon heads the white collar crime practice and global disputes that include cross-border disputes consisting of legal teams from multiple jurisdictions for high-profile clients. Everyone, once again, please put your hands together for Mr. Memon. Thank you, sir. So this mic is over to you.
Thank you, Anjali. Hello. My dear friend, Honorable Vice President of ICC, Mr. Amaya Prabhu, who is on his way, esteemed speakers, ladies and gentlemen, good evening and warm welcome to all of you. A special welcome to all the guests who have joined this event online. As Chairman of the Indian Chamber of Commerce Western Region, I'm thrilled and excited today to have this first hybrid event post-COVID, which marks our return to normalcy. Indian Chambers of Commerce is headquartered in Kolkata and is one of the most proactive business chambers in India. With over 80 years of service to the nation, ICC retains the character of being the premier business chamber with senior industry leaders forming the core of its executive committee. Time and again, its enlightened leadership and membership has enabled the ICC to move ahead and respond proactively to the dynamic changes that have taken place in the world order with a bright vision for the future. ICC is privileged to have members who are renowned industrialists and business owners of leading corporate entities in India who are responsible for charting out policies of the organization. Indeed, the ICC's forte has always been its ability to move with times, anticipate the needs of the future, and suggest proactive measures for furthering Indian business and industry. Today, we have all gathered here to discuss the IBC story, and we are proud to have some of the finest minds in the industry join us on the panel this evening, who will share their valuable insights and expertise. IBC, as you're all aware, has evolved over the last few years, with the Honorable Supreme Court repeatedly making observations about its functionings, thereby timely ironing out the ongoing challenges one faces during the processes. I'm very excited today to hear what our speakers have in store, considering we have some very interesting topics of discussion, which I'm sure will be an enlightening experience for all of us. So, without taking much time, I request my colleagues to kickstart the event. But before that, I would like to kindly call upon Mr. Devanjan Mandal, Managing Partner of Fox Mandal and the Chair of the ICC National Legal Committee, who is joining us via video link, to please throw some light on the theme of this evening's event. Thank you all, and I look forward to an exciting event.
Hello and good evening, ladies and gentlemen. I hope I can be heard. I welcome you all to the second edition of the Indian IBC story, hosted by the Western region of the Indian Chamber of Commerce. I'm grateful to my colleague, Mr. Zulfikar Memon, Chairman of the Western region, for organizing this session for the benefit of all of us. The first edition of the ICC IBC meet was held in the year 2020, and that was just before COVID took over our lives. Now that we have adjusted to this new normal, it gives me immense pleasure to welcome you all for this interesting and informative session. While making my notes for the theme address, I was reminded of the famous Indian folktale about the elephant and the 6 blind men. I'm sure some of us have heard of this story. Since none can see the elephant in its entirety, each of the blind men perceives the elephant, or what it is, based on the part of the elephant it touches. The story of the IBC, its successes and failures in fast-tracking insolvency, is similar. Currently, the World Bank, the International Monetary Fund, the OECD, and our very own, the IBBI, all use their own metrics to study the impact of the IBC on the Indian economy. The IBBI's Working Committee on Tracking the Outcomes of IBC devised a comprehensive and all-encompassing model in November 2021, which I'm sure the IBBI will implement in its full measure in due course. In the absence of a metric that gives us a full picture of the elephantine changes that the IBC made to India's credit market, any assessment of its impact must acknowledge potential blind spots. The IBC was brought in seeking to prevent insolvency, encourage early stage resolution, restructure the credit market, and promote entrepreneurship. It aims to improve the ease of doing business in India. One way to see the bigger IBC picture, therefore, is to ask, how far have we come since the Act was implemented in the year 2016? Some metrics make it look like the IBC story has been a thundering success. By 2019, within 4 years of implementation of the code, India's insolvency resolution process had climbed 56 places in the World Bank's annual Doing Business report, moving from 108 to 52. India also consistently ranks in the world's top 10 improvers in ease of doing business for 3 years after the code came into force. The time taken to resolve insolvency in India, as per the World Bank, has now fallen from over 4.6 years, that's 4.5 years, a little more than 4.5 years, in 2016, to 1.3 years in 2019. So seen from this metric, it's a thundering success. The World Bank also reports that the overall recovery rate for creditors jumped from 26.5 cents on the dollar to 71.6 cents between 2016 and 2019. The IBBI chairperson, Mr. Sahu, stated in 2019 that over 200 companies have been revived by the IBC. So that's the good part, good picture. A closer look, however, would present a concerning picture. The time window to resolve disputes may certainly have improved since pre-IBC days. Those were the days where we had the company court, we had the suit court, and then we had the debt recovery tribunal, then SARFACI, of course, but that also led you to the debt recovery tribunal. Then we had the NCLT, and of course, the IBC in NCLT. However, as per the IBBI's latest data, 73%, and that's a big number, of all insolvency cases overshot the IBC's envisioned 270 days time limit for resolution. So that's 3/4 of the cases in NCLT pending resolution, which have overshot the Parliament mandated time frame for resolution. Thus, glaring delays in several cases have emerged in recent times, indicating that the IBC's promise of fast-tracking insolvency proceedings, and by fast-tracking insolvency proceedings, I don't only mean fast-track insolvency proceedings, I mean fast-tracking of all corporate insolvency proceedings, is yet to be realized. The timeline for admission of insolvency cases was 14 days when the IBC came into force in 2016. Yet, the audience would be surprised that the Economic Times have reported that cases like Jayaprakash and Associates filed way back in September 2018 is yet to be admitted. Real estate company Supertech, insolvency proceedings of which was filed in December 2019, has only been recently admitted by the NCLT of New Delhi on 25th March 2022. Some like Ocean's Arc was filed in 2019, but admitted only in December 2021. That's more than 2 years later. Or Windworld, where the resolutions process started in February 2018, but is yet to see a completion. Even a high-profile case like JP Infra, which was directed to the IBC by RBI, is yet to see resolution, almost 5 years since it was taken to court. Fast tracking of IBC proceedings are a vital component of the IBC success story. The court's aim of making business easier in India depends on the certainty of fast-track proceedings to provide to creditors a time-bound recovery. Timely disposal is very important. It safeguards the company from long-term dilution of assets in the hands of ill-advised management and promoters, ensuring efficient utilization of resources. It also makes it easier for promoters to exit businesses, allowing entrepreneurs to develop a healthy appetite for risk. A variety of reasons exist for the delays. The NCLT is plagued with the problems of capacity and efficiency, practicing primarily in Kolkata and also in New Delhi. I can tell you that even RTIs have revealed that following a slew of imminent retirements, many of whom are eligible for reappointment, in 2022, the NCLT is poised to function at 50% capacity. That means, ladies and gentlemen, that 50% of the members of the NCLT who were supposed to be there appointed to deal with IBC cases also, apart from company law cases, would not be there. Therefore, the NCLT would be poised to function at half of its capacity. Though over 15,000 insolvency and bankruptcy cases remain pending before the NCLT. So this is certainly an area where the government or the appropriate department of the government, which is responsible for appointment of learned members of the NCLT, can look into. Then, lack of set parameters for reorganization and long decision-making processes at the levels of banks and financial institutions also caused substantial delays. Of course, at every stage, the pause of COVID-19 on IBC proceedings have certainly thrown the spanner in the works. But that, as I would say, that would be an act of God. So even if I omit those 2 years, we have lots to answer for, lot to be accountable for, lot to improve. Now, the effect of delays on the economy are sizable. IBBI data shows that creditors recovered only 13.4% of admitted claims in the last quarter of 2021 out of the total admitted claims of rupees 7.5 lakh crores under the IBC till December 2021. The recovery rate is only 1/3, 33.10%. Another concerning insight: only a few high-profile cases drive this 33.10% recovery rate. Some argue that if these few, handful, 3, 4, 5 cases are taken out of the equation, the recovery rate for the average insolvency case will fall down to less than 1/4 or 24%. Now, I have given you a broad overview of the topic. Now, each of the panels you hear today will deal with subjects which may improve the situation. Let me give you a broad overview of the different panels. The first panel will discuss how India fares in terms of recovering debt from cross-border assets. The rapidly growing and globalizing corporate world has given birth to multinational entities that surpass national boundaries, creating an almost borderless relationship among several businesses. Almost every country has commercial relations that extend beyond one or more jurisdictions and consequently have debtors and creditors located at various locations. As a result, if a multinational company were to undergo insolvency, the overlapping and differing legislative proceedings of multiple jurisdictions where such creditors and debtors may be present makes the entire process cumbersome, to say the least. In this backdrop, we look forward from the first panel to an engaging and illuminating session on the available strategies for India to address the issue of cross-border insolvency. The second panel discusses the role played by investigating authorities in the CIRP process, or CIRP, Corporate Insolvency Resolution Process. Among other issues, the panel will discuss the powers accorded to investigating authorities by the Act. They will also throw light on whether more expertise and efficiency will solve the delays plaguing the system. The third session is by a friend and another professional, Ashish, who will give us insights into the Jet Airways insolvency saga. Jet Airways was the first Indian carrier, the airline, to undergo insolvency proceedings under the Cross-Border Insolvency Protocol, along with the Insolvency Bankruptcy Code of India. The final panel, the plenary session of the third plenary session, discusses MSMEs and how to safeguard the interests of small and medium businesses. I am sure that we will hear some enlightened discussions on whether better liquidation prevention mechanisms can be devised for MSMEs to rectify the skewed recovery rates from high-profile IBC cases. A small subset of this, my friends, is fast-track insolvency proceedings. The main purpose behind the inclusion of the concept of fast-track CIRP was to improve the ease of business ranking of our country. Fast-track CIRP proceedings aim to eliminate the excess delay which is caused due to the insolvency process of a small-scale company. In a very brief nutshell, let me tell you what fast-track insolvency process is all about. Then I shall stop my theme address and throw open the panel for discussions. The provisions for the fast-track procedure are laid down in Part 2, Chapter 4 of the Code. Fast-track insolvency proceedings cover small companies, startups, and unlisted companies with a total asset value of less than rupees 1 crore. Thus, proceedings for fast-track insolvency applications to initiate such process can only be made in respect of such specified category of persons. The detailed provisions are laid down in 3 sections or 4 sections: 55, 56, 57, and 58 of the IBC. What does it do? It basically microscopes or cuts down the ideal time within which the process is to be completed from 270 days, which is basically 180 days plus an extension period. It cuts it down to 90 days, extendable by another 45 days. So it basically cuts down to half. 180 becomes 90, and the extended period 90 becomes 45. As the name highlights, the time period for the conclusion of the fast-track process is 90 days, which has to be counted from the date of commencement of the insolvency process. The application will be made against, I've explained to you. The salient features is that it's cutting short the time. By and large, apart from cutting short the time, the rest of the processes are same as in a normal insolvency process. Of course, there are some corners which have been rounded off, but by and large, it's the same. So, ladies and gentlemen, I think that I have spent the allotted time to me. I don't want to extend this theme address further, and I would I would welcome the remaining people, the remaining distinguished guests on the inaugural session to say a few words and to start the plenary sessions. Thank you, ladies and gentlemen. I hope you have a great time.
IBBI since 1st February 2018. Earlier, Mr. Kavdia had been serving at the IBBI since December 2016. Mr. Kavdia is an Indian Telecommunications Service Officer from the batch of 1996. He completed Executive Master of Public Administration from Syracuse University, US, and has completed Executive Master of Public Administration. He also has concurrent certificates of advanced study in leadership in international and non-governmental organizations and e-government management and leadership from Syracuse University, US. Let us everyone, with a huge round of applause, welcome him for a virtual discussion. Thank you.
Thank you. I consider it as my privilege to address this august gathering for this important discussion. And today is a momentous day. I say it is momentous because we are celebrating Azadi Ka Amrit Mahotsav program, able guidance of Ministry of Corporate Affairs, Government of India. As part of that program, we conducted 75 awareness programs in 75 cities in the last 10 days. And today, as I am speaking, we are holding a insolvency professionals conclave just right now. So, this I again extend my best wishes or welcome for all the audience that is present here and all this panelists that are there for the discussion. Friends, we are witnessing an unprecedented reform unfolding before us. I say unprecedented because 10 years ago, nobody could imagine that just by a stroke of pen, large corporates will change into the hands of a professional, that a private person These companies will be revived. The debtors who thought that they had a divine right over the companies will go away. So I don't think many would have thought 10 years ago that all this would have been possible. Even when this code was enacted, nobody could have thought that within a short period of 60 days, that is a blink of eye in legal parlance, this ecosystem will be ready, India will be ready for such a reform. But we have seen everything happen before us. Last 5.5 years is a journey that uh, nobody could have thought 5 years ago. At least I have seen it for last 5 years, and I could not imagine unfolding that way. Let me be very honest. In this last 5.5 years, we have achieved a reasonable level of maturity. This insolvency system has handled more than 5,000 cases. 480 resolution plans have been approved. Uh, this system has dealt claims worth more than 20 lakh crore. All this has taken commitment from many quarters. First of all, this has become possible because of extraordinary commitment from government. We have a economic advisor from Ministry of Corporate Affairs, Ms. Nandini Mishra, with us. She will be talking in detail about the cross-border insolvency. That is the next reform in offing. But the government has been very, very proactive. They have made it clear that this new reform, new code, we are not, we will have to make amendments. And whenever this requirement came, they did not hesitate to going to parliament again and made 6 amendments to the code in just less than 6 years. So as a result, and as a regulator, we also made changes to the regulations as often as needed. And India did not have expertise, but we tried to follow a collaborative approach. And with the help of you stakeholders, industry, the professionals, we have tried to come up with the regulations as the understanding unfolded, as the problems we encountered problems. As a result, we covered this journey in 5 years. We are many developed countries took more than 100 years to reach there. I would be missing in my duty if I do not mention the role that Honorable NCLT and other courts, including the above all Honorable Supreme Court, has played. Such a short time span, they have many contentious issues. This law was law. It has interaction with almost every quarter of life, every law. So they settled many contentious issues. Despite their capacity constraints, they have performed remarkably well and delivered so much. Even for the Supreme Court, they have delivered almost, you can say, one order per week sort of average. They have settled many contentious issues, and a rich jurisprudence has already developed around this code. This it has been possible because of exemplary performance by our professionals. When we started, we did not have any professionals, but the existing professionals who took it upon them and they performed while learning everything. Even IBA was learning. Barring a few exceptions, I think as a profession, as a community, the insolvency professionals have done remarkably well. And in general perception is that the performance of the companies during CRP process was improved as compared when the earlier management was there. So this professionals deserve you can say congratulations, and I must congratulate them for achieving this feat. With this maturity, we have, as we achieved some maturity, we could we are ready for a few experiments. Even Government of India, because prompted by the COVID pandemic, tried for a pre-pack for MSMEs. It's a novel concept for India at least because it's a deterrent position while creators are in control. And as of now, this scheme has not been able to garner much interest, but I'm sure in the times to come, when till now it was competing with some RBI schemes, but on the times of come, this scheme will garner much interest and it will provide a easy resolution mechanism for our MSMEs. And now it's time for looking further up and expanding our toolkit. Uh, Government has already shown some keenness for cross-border insolvency, and our panel will be discussing that in detail. So I won't discuss much here, but I would like to respond to some issues that Mr. Mandal has raised. They are very, very relevant and issues. That it is true that most of the cases are getting delayed. IBA and government both are taking various actions, policy actions to see that the delays, whenever they are happening, wherever they were happening, are reduced to the minimum. And even Honorable Supreme Court took note of this situation, and this case of Ibc case, they mentioned, I will just quote, that judicial delay was one of the major reasons for the failure of the insolvency regime that was in effect prior to the IBC. We cannot let the present insolvency regime meet the same fate. So the Honorable Supreme Court, the government, Parliament, everyone has taken various initiatives to see that the delays do not happen. As insolvency is a subject of competing interest, litigation is anticipated or expected, but as things are getting settled, I'm sure that in the times to come, there will be. And apart from government and regulator, this I believe most of the audience is from industry and professionals. They have to do their bit that this novel feature of the code is not lost. The time-bound nature is the essence of this code. It has to be protected at all cost. It can be said that there are many more haircuts. It is expected because as the code gets settled, the stakeholders know their feet at ex ante. The promoters, if they, for the fear of losing companies, they try to avoid insolvency, they try to settle the dues of the creditors. As per government data, more than 21,000 cases got settled before and after filing of admission, but before admission. And that involved debt of more than 6 lakh crore. It is not a small number. And there is another set where the creditors, debtors paid just on the receipt of notice under Section 8, or just on the threat of filing of a case under IBC, or even did not wait for filing of a case or a notice, because of fear of this code, they simply settled their dues. So this cases that came here were where these promoters were or the management was not able to resolve the insolvency. They could not borrow some amount and settle the dues. That are the cases that are landing here. And even if we consider that all the withdrawals and the closures where the company survived and in the hand of existing management, these are then the case numbers of resolutions from more than the liquidations. So overall, this code is performing well, I can say, and we should not be concerned about this haircut. It only testimonies that the stakeholders know that how this code function, and they don't stand a chance if they are on the wrong side of the law. But again, some challenges remain. This is a market mechanism. This code has put the decision whether to resolve a company or to send it to liquidation in the place of common market. the commercial wisdom of committee of creditors decides what is the best outcome, what is the best resolution. But they also depend on the market mechanism. They only resolve when a good bid comes for resolution. So this market mechanism, the hands of the market has to be strengthened uh, when there are sufficient high number of resolution applicants. There is sufficiently reliable information. There is an information symmetry between the stakeholders. Then only this code can achieve desired outcomes. While we, you can say, uh, enhance our toolkit, we also have to ensure that our existing uh, uh, mechanism is strengthened. We have taken many steps for improving information symmetry. We are placing all the auction notices and liquidation, invitation of resolution form on our website. We have collaborated with Invest India for dissemination of our invitation of resolution plans and public announcements so that we can get interest from outside India as well. Uh, but industry, banks, some resolution professionals all have a duty to see that the assets under stress, IBC, are marketed the best possible. We get most attractive resolution plans. Resolution applicants are facilitated to the extent possible by the law, and we get a good resolution and a time-bound resolution. So we all have a collective responsibility. This reform has been till date has been made possible by the cooperation of the all stakeholders, and going forward also I look forward for all the cooperation from all the stakeholders. With this, I will end my speech and will be keen to hear the panel discussions. Thank you.
Tesh Kavdia, for your insightful knowledge. All right, so now I would like to invite dynamic personalities on the dais, Mr. Ashish Chuacharya and Mr. Amay Prabhu on the dais along with Mr. Mimin. Everyone, can you please put your hands together as we welcome them? Thank you. All right, so now I would like to take the honor to, as we have welcomed him, I would like to introduce Mr. Ashish Chuacharya, who is the partner and head of the restructuring practice for Grant Thornton in India. He is an FCA and an insolvency professional registered with the IBBI, having a good knowledge of the insolvency regime and stressed assets resolution strategies. His expertise lies in turnaround services, financial and operational restructuring, interim management, M&A, bid advisory, and due diligence reviews, as well as advising on insolvency and restructuring solutions for both businesses and lenders. Sir, mic over to you.
Thank you for the kind introduction. And very good afternoon, Mr. Kavadia, if you're still there, and the esteemed panelists and speakers today. And very warm welcome to all the participants, both online and those present here. Very warm welcome to this event organized by Indian Chamber on the Indian IBC story. And when the convener, reached out to me, he asked me to speak for a few minutes about IBC story then and now. I thank you very much for giving me this opportunity, but it just put me in a little bit of a dilemma as to what the real topic is. I mean, do we want to talk about the pre-IBC to what is happening now post-IBC, or is it about the evolution of IBC over the last 5.5 years since we have now seen this reform in place? So I thought maybe I'll just speak a few minutes on both these matters. I think pre-IBC versus what we are seeing now and what is the impact of IBC. I think the reform has been in place for a good 5.5 years, and I'm sure with the interest we are seeing in terms of participation here as well as online, it's a very sought after topic. People are aware of the impact that it has had. I think it's a vast improvement as compared to the previous regime and the laws that we had for stress resolution, recovery. I think the statistics that Mr. Kavadi also spoke about, simply if you look at the number of cases that have gone through the insolvency resolution process, over almost 5,500 cases now, out of which almost 14% have resulted in a successful resolution with a 33 or 34% recovery. These are outstanding numbers when you compare it to the past. Of course, there is a lot of criticism around the haircuts, and you take out the large cases, as Mr. Mandal also mentioned at the beginning, the actual recovery being 24%. But I think it's a little bit unfair to just measure it in that metrics, to be honest. I think one has to look at the impact that this reform has had in the entire ecosystem. I think, the big infrastructure companies, of India that have gone through this process in the last 5 years, if you see, the large steel companies, the thermal power plants, they have been resolved. They've come out much stronger and contributing to the nation itself. Look at the lakhs of jobs that have been saved because these companies have now been resolved and not just, gone into oblivion. So the small vendors, the suppliers of these companies, whose lifeline has been extended. And all this, I would attribute it to this significant reform that we now call IBC. I think Mr. Kavadi also mentioned about the preventive effect of IBC. While I don't have any reliable statistics on this, but I think Mr. Kavadi also mentioned that there are almost 21,000 cases which were prevented or settled even before they were admitted, amounting to 6 lakh crore of debt or dues. That's a significant number, and we have to look at all of this combined to see the impact of IBC. So I'm biased. I'm a practitioner in IBC, so I think this is probably one of the most significant reforms our country has seen in the last decade, and I would rate it probably as high or higher than the GST implementation as well. So moving on to the evolution of IBC over the last 5 years, 5.5 years, I think what's been interesting in this whole time is that our government, our regulators have kept their ears to the ground. They have not just framed a law. Parliament has just not framed a law and let it be on its own. We have seen regular changes, regular amendments to make it easier to implement, to address issues which were not taken care of in the original drafting. As we saw the impact coming from the ground, people were listening, the regulators were listening, and we found changes being made on the go. To name a few, I mean, the most significant one, which I think, and also the most spoken about, is the 29A, which was less than 1 year into the law. The Section 29A was introduced about the ineligibility of resolution applicants. And even today, I think it's the most debated topic. The withdrawal process, there was a way to enter IBC, but there wasn't a way to come out. It was only, you had to go through the whole process of resolution, failure of which led to liquidation, etc. But there was a demand that what if companies, hello sir, what if companies had an option to settle and come out of it? So promptly in June 18, the 12A was introduced, whereby methodology was introduced how to take the companies back out of IBC. I think the treatment of home buyers as financial creditors, that was again, it addressed a very pervasive issue at that time. And even today, I think with the number of cases that we are seeing in the real estate residential sector, that amendment has helped to clear out a lot of issues with respect to how these allottees of real estate projects would be treated. Reinforcement of the timelines, I think that's, we heard about timelines being delayed. There's a lot of criticism around that, but repeatedly the government, the courts have emphasized on the importance of these timelines. the 330-day timeline was, enshrined in code itself back in August 19, and we have seen repeated, enforcement by courts on trying to do this. Of course, there are some structural issues, there are some capacity issues, but I think government is cognizant of that, and steps are being taken. Section 32A, for those of you who will, recall this, the clean slate theory being, established. This was in December 19. It is already 2 years since this was, framed, and this actually led to a lot of confidence in the buyers, because the fear was, once I buy the company through IBC, where is the, what if I am loaded with all the liabilities, the enforcement directorate, they will come after me. But it made it very clear that, subject to certain conditions, of course, of related parties, etc., that none of these would get carried forward to the buyers and IBC. Pre-packs, the last significant amendment, which came in, I think, April 21. I think that's something which there was a lot of demand for this. While 29A, there has been some amendment, some exemptions being provided for MSMEs, etc. But, how to deal with this large pool of MSMEs which are under stress, especially the anticipation was that coming out of the COVID-related, stress, and once the forbearance schemes of the banks and the government was sort of tailing out, how would these companies be handled? So government introduced the pre-pack regime in April 21. Unfortunately, this is one of those aspects which we have not seen, a great deal of success so far. I think there are reasons being debated, and one is to see that, how to make this a bit more effective, but it's certainly something which we all agree is required, because under the pre-pack regime, it's supposed to be much faster, quicker regime. The promoters or the sponsors of the company have the maximum skin in the game. For them to, own the company without going through the lengthy, court process and bidding process, if that could be resolved, it is the quickest way to save an organization. So hopefully we'll see, some better outcome in that. But what I'm trying to say is that, this whole period, and these, what I just mentioned were some of the key changes in the law. I'm not even talking about the innumerable changes which the IBBI has brought into the regulations, the guidance notes, the circulars they have been issuing. So it's been one of the most sort of, I would say, exciting times for, the professionals or the entire ecosystem that's operating around IBC. So it's been a real, interesting case. But I must say that, these reforms, these changes that we have seen in the law itself is not without the support of just so many of you. I think the luminaries who will be in the room today, some of them are already here. Each one of them have led to, these changes happening, because some of the landmark cases that one has seen coming through the courts, NCLT, NCLAT, and going right up to Supreme Court, those cases have actually resulted in the government making those amendments in several cases. In several events, it's been, led by the courts, resulting in changes, and vice versa. So we have seen significant, inputs from all of us in making this happen. I'll just name a few of the landmark cases, and I'm sure they'll refresh your memory. Of course, SR Steel case is the most spoken about case right up to 2019. I think it set out so many principles in IBC that today they are either form part of the law or certainly the practice. The role of the resolution professional with respect to resolution plans, the enforceability of 29A, person acting in concert, the commercial wisdom of COC being, that was the first time when commercial wisdom of COC was held supreme, and thereafter there have been so many cases where that has been reinforced by the Supreme Court. So SR Steel case, I'm sure, a lot of us know about, what happened there. The Ibc judgment, again, a very interesting judgment. I think it was also mentioned by one of the previous speakers, which spoke about the binding nature of the resolution plan. That once a plan has been approved by the COC, it is binding upon everyone, including the resolution applicant. You cannot make any changes, even while the NCLT is yet to adjudicate on that. So that was a very interesting case. Ghansham Mishra, I think in the last 2 years, probably, has it been about 2 years in Ghansham Mishra? Maybe a little less, or 2 years or so. It happens to be one of the cases where, I was personally involved in that resolution process. The Ghansham Mishra case, I think, has been the most quoted case law in the last 2 years, with the clean slate theory being affirmed, and that the claims from the pre-ICD cannot cross the line, whether it has been submitted as a claim or not. So that gives great deal of confidence to resolution applicants. That gives a lot of, that I'm not going to be saddled with the issues of the past once we have bid for the company and taken it over. The Maharashtra Seamless case was another landmark case, I think, when we spoke, where it was established that resolution plan values do not need to be higher than the liquidation value. The liquidation value as determined by the fair valuers, that does not need to be higher than that. The commercial wisdom of the COC to decide whether a plan is worth approving is most important. So there have been so many such cases. I mean, I can go on and on. The more recent ones, it was literally, I think, a month ago, the Noida authorities case. Again, in real estate cases, we have seen that one of the big challenges that was being seen by the applicants is that how do you deal with the land authority dues, and whether authorities like Noida who get EDC, IDC, are they considered operational creditors, or they have a separate category. Finally, Supreme Court has adjudicated that they are to be treated as operating creditors, so which gives them the same standing in the waterfall as anyone else. So this will probably speeden up so many cases which are held up in NCR with respect to the real estate projects. So this was a recent one. And Seva Industries, a little controversial recent case, but it again simply reaffirms the commercial wisdom that courts are not going to get into the commercial wisdom. If the COC is decided by 90% majority that they should withdraw a case, that's final. Courts are not going to intervene. So some of these things have been reaffirmed by courts. It makes the functioning of and hopefully this will slow down the rush to courts that we have been seeing. For everything, people are running to the courts, and that just clogs the system. So hopefully we'll start seeing the benefits of these case laws coming through now. Yeah, it's been a mixed bag as well. I think some of the recent orders have caused some trouble and rocked the boat a little bit. I think some of you may remember the Amit Metallics case, which is from Supreme Court, recently spoke about the distribution pattern to dissenting financial creditors. Now, that's a little bit controversial in the way it has been dealt with. There are other cases, similar cases, which are going through the courts, and hopefully we'll see some correction in that. But I think the way that order is laid out, it can, it impacts the banking system a fair bit. And we have Mr. Bansal here who can share his comments later on about this as well. I think, so there have been substantial changes and evolution of the code, I think, today, but that's not all. It's not over. There are still several areas that we need to still deal with. We have to, the cross-border insolvency, which has been, a discussion paper. There's a committee formed. We were actually expecting that by the budget session itself that we should see some, something come through. But unfortunately, I think government had other compulsions. But I have personally been involved in the first cross-border case of India related to Jet Airways, and I'll probably speak about it later. It would definitely help if we had some framework to follow. Avoidance transactions, how to deal with these filings that are done once the plan is approved. I think that's another big gray area. Again, it's being debated in the various forums. That recently I was invited to a roundtable with the regulator as well, as to what should be done. As an RP, one is responsible to make the filing, But once a plan is approved, what happens? Who's going to pursue that case? Who's going to get the benefit of the recovery? Who's going to pay for the legal cost? So there are some unanswered questions there, and there can be some substantial values that can be seen there. Is it a time for relaxing the 29A? It's a very controversial topic, but it is being debated again that now that the large cases have gone through, how are we going to get buyers? How are we going to get resolution applicants? Do we need to make some relaxations there? While MSMEs, there has been some relaxations already provided, but is it time to widen that? I already spoke about prepackaged insolvencies. In my view, it should be, the thresholds need to change, need to be improved, sort of go up beyond MSMEs. Then we'll probably start seeing, see, one of the things that has happened in the last 5 years, that because of the large cases gone through, we have seen so much jurisprudence come up, right? Because these are large cases where they have got a lot of value in it. So the courts get involved, the lawyers are involved, the best experts are going behind it. So the cases get established. Whereas in these MSME cases, we have not yet seen, to my mind, to my knowledge, there's, it's in single digits where the number of prepack cases which have been filed. And I don't even know how many have been resolved yet. I think my last comment would be on, again, small shareholder interest. I have been a big advocate of saying that once a company enters into insolvency, and this for listed companies, of course, there should be a suspension of trading. This is something which I've been saying from the beginning, and a lot of mature insolvency regimes do follow this, where when the company enters into insolvency, there's immediate suspension of trading. But I think in India, we have not done that yet. There is a debate on this as well. We had approached stock exchanges and SEBI, I remember in the early days, and there the view was that, no, we need to protect small shareholders so that they're able to exit. But honestly, in my personal view, it's actually quite the reverse that happens. The small shareholders are the ones who actually get stuck in the speculation that happens in the market and the wild swings in the market. So that's something which, again, I would advocate, through policy groups, that something should be looked at. So there's still a lot of work that still needs to be done in IBC, but I think we have come a long, long way. And I do hope that I'm part of the journey going forward as well. Thank you very much.
Thank you, Mr. Ashish, for sharing your valuable expertise. Thank you. Coming up next, we have Mr. Pradeep Sureka, the President of ICC and MD of Sureka Group. So we have a recorded video which we will be sharing with everyone. All right, so before we do that, I would like to take the honor to introduce him. Mr. Pradeep Sureka is the director in charge of the real estate division of the Sureka Group, which also has major interests in the manufacturing and distribution of bicycle tires and tubes. Mr. Sureka has 35 years of experience in the real estate industry, having started at the young age of 20. Under his leadership, the Sureka Group has grown and consolidated its position in Kolkata and expanded into Hyderabad and Odisha. The Sureka Group and its associates are involved in diversified landmark projects like South City, having the largest mall, 1,600 apartments, and a school. Urbana, spread over 65 acres with nearly 7 million square feet of concepted space in Kolkata. The Sureka Group has also created nearly 1 million square feet of IT space in Kolkata and has also been involved in developing affordable housing, having delivered over 800 of such units in the last decade. Mr. Pradeep Sureka is also involved in Altair, a landmark project in Colombo, Sri Lanka. Mr. Sureka is currently the Senior Vice President of Indian Channel of Commerce. Everyone, can we have a huge round of applause for him? So we are sharing a pre-recorded video with everyone. Thank you.
I would like to thank Mr. Ritesh Kavadia for gracing the occasion. I would also like to mention the efforts of Mr. Debanjan Mandal and Ashish Chuacharya, chairpersons of my legal subcommittee, National Legal Committee, and the IBC committee for putting up this discussion on this very valuable and very important subject. I definitely have to thank Zulfikar and my Vice President Amir Prabhu for hosting this event in the appropriate city of Mumbai. The IBC has been a transformation and a revolutionary act in India, where for many years the non-performing assets were becoming really truly non-performing, having not been considered for re-ownership or relook at the appropriate time. And the laws were cumbersome for transfer of such assets and recovery of money of creditors. So I appreciate the centre's effort to implement the IBC in the year 2016. However, any new law has its own challenges, and I think in the last 7-8 years, many case laws, many court orders have ironed out many of the challenges and difficulties of this law. And I'm sure today's seminar and the discussions held by the dignitaries and the prominent speakers connected with this law will make a lot of effort and make a lot of difference to how the IBC Act should progress and how we can create a white paper from our chamber to help the government, help the legal system in ironing out the challenges currently faced under the IBC. With this, I wish my team and the guests a fruitful and a constructive deliberation on this act. Thank you.
Coming up next, I would like to introduce Mr. Amaya Prabhu, who is the Vice President of ICC and an entrepreneur, founder, and Managing Director of NAFA Capital Advisors Private Limited. He's also a partner in UAP Advisors LLP. So everyone, please put your hands together as I give the mic over to him. Thank you.
Thank you, and good evening, everyone, both who is present here physically and virtually. I'm meant to deliver the vote of thanks to all of our speakers, but I would also like to thank all of the audience who's here both physically and because on a Friday evening to probably spend your evening listening to stuff on IBC, I'm very, very impressed. That shows real commitment on behalf of all of you to be here, and I'm really actually impressed by the number of people who are here. I'm also one of you. I'm also here to learn. I think I was just sharing with Ashish Chuacharya ji that some of the points that he made, I was writing them down because I think the points that were shared were so interesting. And I believe that one thing which I greatly admire about the IBC law that was passed was the fact that they have constantly evolved it. I mean, the biggest problem that we usually mean, there are great legal luminaries here, but the biggest problem that we see with laws in India is that you will still have a law from 1880 passed during the British era, which, I mean, the other day we were discussing along with our president and when we had a meeting with the SVP president and I, along with Dr. Singh, who's our SG, that one of the things we want to petition to the government is that there are so many old laws that actually are against. For example, there's a law in a certain Indian state that you have to paint your toilet every 6 months. And if you don't do that, it's a criminal liability on the directors. non-bailable, as Zulfi, as a criminal lawyer, has told us here, that it's a non-bailable this thing. So I think the great thing with the IBC, and I must really commend both IBBI and the government, that they've constantly evolved this law. And again, he spoke about section 12, where I wrote it down. We often talk that Abhimanyu knew how to get into the Chakravyuh, but not to how to get out. But I'm very happy that we haven't made the same mistake from the Mahabharat, and we have an ability to also exit this. I would also like to take this opportunity to, of course, thank each and every one of you, but also our speakers. Mr. Mandal made some excellent points. Chuacharya ji also made phenomenal points, and of course, Zulfi, our Western Region Chairman, under his leadership. I really do hope that we can do a lot more of these events, which not only are important from an ICC community building point of view, but all of us shall definitely leave today at least slightly more informed than when we came. I certainly already feel the same. And I think we need to, I think one of the great things with the IBC is the fact that it enables institutions to continue. I think what we need to realize is that it's very important to allow institutions, to allow brands, to allow, despite whatever the short-term problems may have been, in certain cases, they may be due to mismanagement, in other cases, due to market forces. I mean, not all businesses fail because of just fraud. I mean, I think one thing which we need to also realize and put it into our mentality, that sometimes market forces also affect businesses. I mean, in today's dynamic economic environment, there are a lot of businesses, both in COVID and as well as today with the inflationary and the current economic issues that are going on, which may or may not survive this. But I think it's important to give them a second lease of life. It's important to give the suppliers, the vendors, a second lease of life. And most importantly, it's important to protect jobs. Because the biggest issue that I foresee in our country is jobs. Our MSME chairman is nodding his head, but I think his MSME is the heart and soul of our economy. And I think what is very, and all of it, let's remember, ultimately, a big business is like a big river. But that big river is fed by several tributaries, by several streams, and those are the MSME sectors. And I think protecting companies is also protecting MSMEs, which is an important thing that the government needs to look at. It's important to protect the supply chain, and I think hence we need to continually support IBC. I think I would say the one big worry that I took off from today is that I was told that IBC will only operate at 50% capacity. So I think what's very important is we need to get more judges. We need to, maybe some of our speakers today could also spare some of their time for a few years, maybe go in. I was told that that is a provision that wherein some technical experts can also be members of the IBC. I do hope some of you could also dedicate some time to the nation, be on the other side, serve back, give back to the government, because it's only through the participation of people like all of you that we can do a lot more for the economy and help address some of the challenges that come in. So I do hope the IBC can operate not at 100%, but more than 100% capacity, and I think that's a challenge which we need to address. And again, thank you everyone for being here. Thank you for supporting not just the IBC, but also the ICC. And we really appreciate your time. And I do hope this is a productive and fruitful evening. Thank you.
Thank you, Mr. Mayor. Now the time has come for the felicitation of our honorable guests. And to do the honors, I would like to invite on the dais a very beautiful personality and a great professional, Ms. Nadia, on the dais to do the honors. Thank you.
A very warm welcome to everyone. What a fantastic inaugural session this has been. I think this has set the stage perfectly for the next session and the next speakers to come on board. But before that, we believe that every good initiative has to start with thinking about the earth and giving back to the earth. And this is one of the best token of appreciations that we could give our speakers, that the ICC is going to plant 10 trees per speaker as a token of appreciation and go green and give back to the community. With that, I would want to facilitate our speakers.
All right, so now is the time to meet the seasoned and subject experts and thought leaders for the plenary session 1 cross-border insolvency for the Indian IBC story organized by the Indian Chamber of Commerce. The panel members comprise of Mr. Janak Dwarakadas, Senior Advocate, Mr. Shardul Shroff, Executive Chairman, of Shardul Amargand Mangaldas and Company, Miss Tal Goldsmith, the partner of Stephenson Harvard LLP, Miss Nandita Mishra, economic advisor to the Ministry of Corporate Affairs, Mr. Vyapak Desai, FCI ARB, Head of International Litigation and Investigation, and Nishit Desai Associates. And the panel will be moderated by Mr. Shaurya Mandal, partner of Fox Mandal Solicitors and Advocates. Let's begin this event. Thank you. So I invite all the honorable guests on the dais to start with the session. Thank you. The mic is over to you.
Good evening, ladies and gentlemen. I would like to firstly thank the Indian Chamber of Commerce for organizing this important event and giving us this opportunity to be part of this important panel. It is a pleasure and honor for me personally to moderate such a great panel of speakers. Our topic today is cross-border insolvency, a long due dream. Although the IBC has been in force for more than 5 years, we still don't have an effective legislative framework for cross-border issues. For cross-border issues, the IBC in its present form has certain sections which basically deal with enforcement of orders of Indian courts outside India and for the protection of foreign assets belonging to Indian debtors, Indian companies. But the most important issues relating to enforcement of orders by foreign courts and enforcement of orders passed by foreign courts in India and other relevant issues have not been covered by IBC in its present form. I think the government has realized this lacuna, and in 2018, the government set up the Insolvency Law Committee for the purpose of looking into cross-border insolvency issues. The Insolvency Law Committee, ILC, came up with a report in June 2018, putting forward views on how cross-border insolvency issues should be handled, and also proposed a draft regulation, or rather it was called a separate part which was to be added to the IBC. This part was modeled on the UNCITRAL model law, which has been in force in more than 50 countries all over the world, including US, UK, Singapore, Korea. Thereafter, the government also set up a cross-border insolvency rules and regulations committee, which was formed for the purpose of implementing cross-border issues and the draft regulation that was proposed by the ILC. Thereafter, in 2021, the Company Affairs Ministry issued a notice requesting all people to give comments on these draft regulations and also propose certain changes which they thought was important. I am not sure what the current status of these regulations are, And we would be looking to Madam Nandita to enlighten us on what is the way forward. There has been very few judicial precedents regarding cross-border insolvency in India. The only two important ones that come to mind are the Jet Airways case and the Videocon case. And we have Mr. Ashish Chuacharya here, and I'm sure he will speak about that from his perspective. But on the legal side, Mr. Dwarkadas here will be discussing these cases. We have a galaxy of speakers from India and the UK, and we are particularly happy to have Mrs. Nandini Mishra from the Ministry of Corporate Affairs as a panelist. We will wait to hear from her about the government perspective and the plans on the way ahead. We will today start with Tal Goldsmith, our speaker from London. The UK has adopted the UNCITRAL model law for many years, and we would like to hear about their experience with cross-border insolvency and what she sees as the pitfalls they have faced in their journey. Her talk will set the stage for further deliberations by the other speakers and how India will address this important issue. That's it, and I hope we will enjoy this panel from a great set of speakers. Over to you, Tal.
Thank you, Shuri. It's a pleasure to join you from London this evening. So I'm very honoured to be part of this prestigious event. As you mentioned, the UK has a long tradition of cross-border insolvency. We are really a small island, and so we have been trading, as you know, for centuries. We have to. And as a result of the trade, there is dispute. And so I had a look this morning, and the earliest cases in our textbooks are from the mid 1700s in terms of cross-border insolvency. And so I thought it might be useful. This is an exciting time in India's development of this regime. And I thought it would be a useful thing, perhaps, just to share a couple of points about things that have arisen and that we as practitioners in the UK find in relation to our sort of global asset recovery, in my case, practice. The first thing is that we have more than one cross-border tool in the UK. We have the model law, which is enacted into domestic law by a regulation. So that is the sort of empowering global statute. We also have separate tools in our domestic insolvency law, freestanding, away from the model law. And they provide, particularly with territories we are very close with, for example, the Channel Islands and some members of the Commonwealth, provide gateways with very close gateways. And then we have the common law. We have hundreds of years of cases. Sadly, until recently, we also had the EU regulation, but that is no longer. So we now have three sometimes overlapping sources of law, and that means that the courts can be quite flexible. When there is a problem, a foreign office holder or a foreign state wants to come to the UK to use our powers to gain control of assets or get information on assets, debtors, we can be quite flexible about it. And I think the important thing to say about flexibility is that when we're looking outbound at countries that we would bring our proceedings to and try and register and get our insolvencies recognized abroad, when we're considering global strategies, the law is only the first, is the starting point. So the adoption of the model law for us is obviously it's a really helpful starting point. But the practicalities of what is in the domestic law, what is in your toolkit of the foreign state that we can use to recover assets, because the certainly if you come to England, the way the law works for us is that the Foreign Office holder has to use our laws to recover assets in England, even if they're recognised. So that is the same. We have to look at if there are territories with very limited transaction avoidance strategies or laws, those are generally avoided. Equally, where courts aren't fast, efficient, helpful, no matter what's in the legislation, it's the practicality on the ground that makes territories either attractive or unattractive to foreign practitioners. Definitely a specialist court with specialist judges helps. You know, in London, it's the Insolvency and Companies Court that hears, in the ordinary course, hears applications for recognition, and it means the judges are familiar. It takes less time. You don't have to go through all the rigmarole. You can get recognition very quickly, and sometimes foreign office holders do use those tools as a proxy for claims, because instead of attempting to get a freezing order, issue a claim, very expensive, if you can prove a debt, you can potentially wind a company up or bankrupt someone and then come to England and grab their assets immediately, you know, on a short interim application. So it's the practicality of what happens in the regime rather than the sort of the statute. And the best example of this is the EU regulation we were part of. It was designed to give automatic recognition for each member state to each other member state. So that should have made it very easy throughout Europe to recognize insolvency proceedings. In fact, there are jurisdictions where all of us practitioners shudder if we think we have to go there, because we know there will be delay and we may not even get recognized. The courts are not helpful. They don't want to assist. The other point I wanted to make is on inbound proceedings, so ones that come into the UK from abroad. I think there's sometimes a concern that when you're allowing all sorts of foreign representatives to come and have powers in your jurisdiction, that there's a kind of a takeover or you lose a bit of control. But certainly in England, the judges retain a pretty wide discretion to curtail behavior that is unacceptable, doesn't fit with our public policy, or is otherwise abusive. So for example, if a totalitarian state wanted to use an insolvency proceeding to expropriate assets unlawfully, whilst our jurisdiction is very friendly to everyone, please come, they will take steps to manage foreign office holders and foreign proceedings so that there is no or the limits on the amount of abuse that can occur in the local courts. And my sort of final point is I understand that the adoption of the model law as it's currently proposed only relates to corporates. And what I would say from my perspective, certainly from the English cross-border experience, is that the direct route against individuals is how we get the corporates to pay. From the many cases I've done, it is actually billionaires are quite often prepared to sacrifice parts of their corporate entity, but if you stop them going to the country club or their wife going on holiday where she wants, suddenly there are powerful personal motivators to pay. And with recognition of bankruptcies globally, what you have is an ability to gain control of an entire ecosystem of companies. You know, a lot of these people have hundreds, if not thousands, of corporates all over the world, and you would have to knock over each one or each chain of companies if you went against the corporates. Whereas if you manage to get a bankruptcy order against the individual and can take it to all the jurisdictions where there are assets, you can shortcut and make much more efficient the asset recovery global strategy, which obviously is what we're here for. Well, I am here. My job is to maximize global recoveries for creditors and minimize costs. And it's the second bit, which is the hard bit, where you have competing local processes globally. You have just many more sets of professionals. And whilst that's wonderful from a fee generation point of view, it is not good for recoveries for creditors, which is what this whole system is designed to achieve. So I do think having a system where we can globally recover against the individuals is also very important. So I suppose my parting and most important point is it's actually how the law is implemented in the jurisdiction that is the most important part of the law itself. So enactment is only the first step. The rest of it, and being an attractive jurisdiction to cross-border insolvency professionals like myself, it is about an attitude and the system being designed to facilitate assistance. And that's I think I'm handing back to you, Shura.
Well, thanks a lot. Well, and I think it's a very interesting point you make about making individuals also responsible under the insolvency regimes. And it's a very interesting point in India as well, in the sense that although individuals who have been guarantors are now covered or the provisions are effective relating to these individuals, but other individuals for non-guarantee claims are still not covered by the IBC as it stands today in terms of being enforced. So I think this is also an issue which the government has raised in its report, on the draft that was prepared earlier by the ILC. And it'll be interesting for us to see how the provisions against individuals are fully implemented. And I think it is only then that the cross-border provisions will also be more effective. Thanks a lot, Tal, for the UK perspective. And now we turn to Mr. Dwarkadas to give us his views.
Thank you very much for inviting me here. It's a pleasure to be here. Warm welcome to all of you. Good evening to Tal, and really appreciated your inputs on the UK experience. And I think the last 2 points you made were, according to me, the most significant. The first is that enactment of a law is only part of the problem, but it is really the first step, and it ought to be the first step. And the second point you made was how it is implemented is equally important. I think these two indications coming from a person who's been practicing on this particular subject across UK and outside in the EU tells you a lot, and I'll tell you why. I have been asked to speak about the 2 decisions which are today being regarded as precedents in our country, namely the Jet Airways case and the Vodafone case. I mean, the Videocon case, sorry. I looked at the 2 cases. My first blush reaction was, we seem to be heading in the right direction. The absence of law or the void in the law is plugged, so to say, by the 2 decisions, one of the NCLAT in the Jet Airways case and the other in the Videocon case by the NCLT in Mumbai. On a deeper reflection, I am sorry to say that NCLT and NCLAT, being creatures of a statute or tribunals created by or under a statute, have usurped I'm sorry I'm using strong expressions, but I mean it and I'm conscious of it, have usurped powers reserved to the legislature or the 141 power that is reserved to the Supreme Court to do complete justice where there is a void in the law. I do not think either the NCLAT had the jurisdiction to pass an order of the nature that it did, namely to force upon the parties what is described as a cross-border insolvency protocol and make it part of an order of the court or the tribunal. In the Videocon case, it is even worse. The debtor, that is Mr. Dhoot, goes to the NCLT and calls upon the NCLT to take into consideration the share of foreign subsidiaries in the joint venture companies in Brazil with regard to oil and gas assets belonging to a joint venture company in which BPCL has a 50% share and offer it for the resolution process in India. And NCLT says, we'll apply, we'll lift the corporate veil, we'll do this, we'll do that, we will ignore the law, and we'll make law. Of course, you can bring this into the resolution process. A very, very, very dangerous precedent. And I'll tell you why. As was said by my friend Tal, enactment of a law is the first step. Why is it important? There are two sections in the IBC. I'm afraid both NCLT and NCLAT, whose attention was drawn and they've referred to them in their decisions, have paid lip service. They have not really understood the impact of the sections or what they stand for. I'm going to read to you one section. The other one is not as important because I'll paraphrase it for you. But section 234 is part of our IBC as legislated, number one. What is even more important is that both these decisions recognize that at the time when the decisions were rendered, neither of these sections had been notified. Some books which are not government publications, which I had access to in the limited time that I had, use the word enforced. I don't know what that means. I have not come across a word enforced with regard to a section which is required to be notified, but I will proceed on the basis that at the time when the decisions were rendered, these sections were not notified as is indicated by the decisions themselves. 234 says, the central government may enter into an agreement with the government of any country outside India for enforcing the provisions of this code. Now, this is what Tal referred to as outbound. Then it says, the central government may by notification, there is no notification. This section itself has not been notified. But subsection 2 says the central government may by notification in the official gazette direct that the application of the provisions of this code in relation to assets or property of corporate debtor or a debtor, which is an insolvent personal insolvency or a personal guarantor, of a corporate debtor, as the case may be, situate at any place in a country outside India, with which, please mark these words, with which reciprocal arrangements have been made, shall be subject to such conditions as may be specified. Each and every word here is important because none of them, not a single one of them, was available at the time when the orders were passed. Is this not legislating? The second section is 235, which is only a section which says that the NCLT, the government has a power to issue a letter of request where the assets of a corporate debtor are situated outside India or country outside India, but qualified to say with which reciprocal arrangements have been made. Under section 234, an application is required to be made to the adjudicating authority that evidence or action relating to such assets is required in connection with such process or proceeding. So it is not something that can be done at the will of a tribunal which is constituted under a statute. Unfortunately, these sections have been lost sight of. Now, what is the effect? Why do I bring this up? I don't want to bore you to death with the details of the facts of each of the cases. They are not so relevant to the issue here. We are talking of cross-border insolvency. In Jet Airways, let us take Jet Airways as the first case. What was the issue there? The Dutch proceedings, or the lessors of two aircrafts in the Netherlands, moved insolvency and got orders of insolvency against Jet Airways in the Netherlands. So it's an order of an insolvency court. There is a Dutch administrator or trustee appointed. He's acting under the jurisdiction and orders of a court, of an insolvency court, which is vested with jurisdiction in the Netherlands. So he's not just a representative. Despite that order being in operation, despite there being no reciprocal arrangement, despite there being no model law in place, despite there being no cross-border insolvency protocol entered into with the Netherlands, an order is passed first by the NCLT to say the proceedings in the Netherlands are void ab initio, nullity. They are a nullity. I mean, I don't know how even a High Court or a Supreme Court could have said it, but fortunately, at least that part of the order was set aside by the NCLT. I'm just telling you the length to which the tribunal in our country has gone. Then the matter goes to the NCLT because the NCLT says, oh, it doesn't matter, these are all assets which ultimately, they are all assets of the company whose registered office is in India. We have jurisdiction over it. We are the adjudicating authority. How dare some Dutch administrator or trustee come and tell us what we can do or cannot do? We will take charge of the aircraft. Anyway, so the matter goes to the appellate court. The appellate court, maybe because it was headed by a judge who was a retired judge of the Supreme Court or whatever, I don't want to comment. He decided maybe he still has some 141 powers available with him or what, I don't know. So he says, don't worry. Let's not worry about 234. Section 13, 44A of the CPC doesn't apply. In any event, 44A only deals with money decrees. So there's no reciprocal arrangement. So we don't have, there is absence of law. 234, 235 are not notified. What do? You come here, Danish trustee, you come here. You will enter into a protocol. With whom? With the RP of the Jet Airways appointed by the adjudicating authority, Mumbai NCLT. You shall sign a protocol and you will submit to orders. You will not do this, you will not do that, you will reciprocate, you will cooperate, you will be given a right to attend the COC, but you cannot vote over there, you can oversee the operations, you will bring all the information about your Dutch insolvency over here, we will sit in judgment over it. If we like it, we'll accept it. If we don't like it, we won't accept it. We will see to it that the aircrafts are not sold. You also cannot sell the aircraft. You will take part in the resolution process. But in all this, I don't want to bore you because it's pages and pages and pages. The protocol runs into hundreds of pages. In all this, one objection that was raised was that, look, this is a resolution process. The IBC in India has a different goal. The goal of the IBC in India is maximization of value for the purpose of putting the company back on its rails if possible. So resolution. Whereas the object of the insolvency laws across the world is to bring a closure, and that too for the benefit of every stakeholder. Here, only the financial creditors have a voice. The rest of the stakeholders have no voice. So the NCLAT says, but look, that is a lacune. See, we must plug that lacune in because otherwise only the financial creditors will get the benefit. So we must bring the aircrafts into the fold of the resolution process in India, and therefore we need this protocol. And they say, okay, now you sign. Now, it's all very well, it sounds very good on paper. It's sort of, maybe the asset base of Jet Airways went up or whatever, I don't know, I appear in the matter, but that is irrelevant. I'm just saying, when you apply your mind to something, you realize that you cannot legislate. How can you take away the powers of the Dutch, the Netherlands court? Supposing today, the reverse had happened. The Dutch insolvency court had said, we don't care two hoots. We are putting this company to an end. We will go ahead. We will dissolve this company. We don't care. We have the jurisdiction. So what if it's not the main registered office? We have the power. We have the jurisdiction. We'll wind it up. You'll create a conflict. Is that desirable? Therefore, this section was enacted, with which the country outside India with which reciprocal arrangements have been arrived at, subject to such conditions as may be specified. You can enact whatever law you like. You bring that part Z and put it into your law. If it is not in conformity with the UNCITRAL model, I dare say other countries may say, sorry, we don't like it. We don't know. If they are free to say, they are sovereigns, they can say, we don't like your law. We don't want to enter into reciprocal arrangement. We will not recognize your decrees, just as you are not willing to recognize, or your public policy says it should be revived. Our public policy says it should be wound up. We are not at idem on this. So please see, it is not as simple as it looks. On paper, the judgment looks very attractive. It seems to favor us, so we accept it. We crow about it. We clap our hands and we say, what a great judgment. But I'm sorry, I do not agree with it. Similarly, in Videocon, what happened over there? In Videocon, as I said, the Dhoots who were in charge of all the Videocon companies, first of all succeeded in bringing about a group insolvency. Fine. Maybe that's a matter of internal interpretation or whatever it is of the provisions of IBC. I don't want to comment. So 12 companies under the fold of VIL, corporate veil was lifted. It was held to be a single economic unit, etc., whatever law was applied, and all 12 were amalgamated into one. Fine. Then, encouraged by that thought, the promoters of Videocon say, let us go one step forward. See, we are shareholders of a JV. Maybe there is BPCL who is our JV partner. How does it matter? Maybe 100 years ago, the Privy Council had laid down the law that no person, no shareholder can claim that he has a share equal to the percentage of share he holds in the company, in the assets of the company. Maybe it was so, but we don't care. So if you're a 25% shareholder, you can say 25% of the furniture in this room belongs to me because this is 25% of the total number of assets of this hotel. There is no law like that. But they said doesn't matter. We will say we have got 50% share in the JV. We will say take the assets in the oil and the gas business of a JV company where is another partner which is located in Brazil. Of course, the fact that Brazil courts may have its own jurisdiction, they may have something else to say, it doesn't matter. We don't need to worry about them. Our public policy is more important. So we take those assets and we put them into the insolvency over here. Why? Because it enhances the base. So NCLT Bombay says, of course, bring them in. It will be good for the whole insolvency resolution process, but there is no reciprocal arrangement. If Brazil were to pass an order dissolving that joint venture company and lay its hands on the ground that it is the operations of that subsidiary in Brazil, which is the principal place of business and its registered office is located over there, and it is in fact subject to full jurisdiction of the courts over there, I wonder what would happen. So you will have a situation where the jurisdictional court, which can actually take charge of those assets and utilize them for the purpose of insolvency and for the benefit of the creditors in Brazil, is taken out of the jurisdiction. I mean, if you were to take a limited example of a physical asset, it's like picking up this table with 6 chairs and taking it to India and saying, here, use this in the resolution process. Because we say so. So please try and understand. I'm only giving you an illustration. We don't have all the time. So I think I will wind up. But please keep this in mind. I just thought I'll place this before you. Thank you very much.
That's a very interesting perspective on these two decisions. I think now we'll request Mr. Shroff to give his views.
Shaurya and the other members on the dais in Mumbai, and colleagues who are on the video, on the hybrid connectivity, and participants who are hearing this conference. I think we've had a scintillating talk by Mr. Janak Dwarkadas, completely exposing the inadequacies of both the judgments of Jet Airways and the Videocon case. What is significant and what I would like to say before I take up my portion of what I'm supposed to say is that the law, as is contained in section 234 and 235, contemplate an agreement for enforcing the provisions of this code. So if the principles of CIRP were to be introduced in an agreement with reciprocity, whereby two countries who are contracting agree to apply the principles of the CIRP, and it is notified as per section 234, then and then only will the jurisdiction of India's CIRP process come into play. Now, let us take the model code of cross-border insolvency. By very expression, this law is only about insolvency. And it is therefore not a complete law in relation to the revival process or the resolution process involved in the entirety of the IBC Code. The law, namely the law of cross-border insolvency, only deals with the insolvency issues in relation to the entirety of the IBC. Therefore, it is not permissible for any tribunal to apply the issues concerning rehabilitation or revival, assuming that the model code is made part of the Indian law. This is a very significant issue that must be understood, that it is not as if the aspect of restructuring across countries is going to be provided or legislated upon by introducing the model code of UNCITRAL concerning cross-border insolvency as part of local law. Our constitution proceeds on the footing that the agreement or the model code has to be in the nature of a treaty. And as a treaty, it can be embedded into the Indian law. Whereupon, as a contracting party, one can provide that there will be 4 or 5 features of a law which is akin to a law accepted by 50 countries or signed off by 50 countries in 54 jurisdictions. This is what is the background of the UNCITRAL model law of cross-border insolvency. Incidentally, on the 30th of May 2022, the UNCITRAL model code of cross-border insolvency achieved 25 years of existence. So just 10 days ago, the law made it a 25th anniversary in relation to the model code. There are 50 countries across the world in 54 jurisdictions who have signed up to the UNCITRAL model on the cross-border insolvency. Now, what is the genesis and why is there a cross-border insolvency law necessary under the auspices of UNCITRAL? The purpose of a model law as designed is to assist states to equip their insolvency laws with a modern legal framework to more effectively address cross-border insolvency proceedings concerning debtors experiencing severe financial distress or insolvency. It focuses on authorizing and encouraging cooperation and coordination between jurisdictions rather than attempting the unification of substantive insolvency law, and the process therefore respects the differences among national procedural laws. For the purposes of the model law, a cross-border insolvency is one where the insolvent debtor has assets in more than one state, or where some of the creditors of the debtor are not from the state where the insolvency proceeding is taking place. So in the case of JET, as was explained by Mr. Janak Dwarkadas, the Netherlands had the planes belonging to Jet Airways and was undertaking trade in Netherlands by actually flying passengers in Netherlands, and those assets were not owned by the Jet Airways. They were only enjoying a lessee's right in relation to the use of those planes. To then say that they must be brought within the fold of Indian insolvency or Indian CRP is an absurdity by any count. Firstly, assuming that there was a model code, the code was only in relation to insolvency and not restructuring, because there is a separate code in relation to dealing with enterprises, multi-global enterprises, which few countries have adopted, but certainly it is not even in the realm of thinking in India as part of the development of law or as a part of the Insolvency Law Committee's agenda. That's a completely different thing. Therefore, this issue of subsidiaries, which Mr. Dwarkadas mentioned, is a law governed by the separate process of the model law on enterprises and not the model insolvency law on cross-border insolvency. So there is a complete confusion which has been created by these two precedents, and the sooner they are set aside and the sooner they are not relied upon as if they have made good law, the better for us. Now, again, going into the question as to what is the relevance of introducing a model insolvency law? It is basically because our law has not kept apace with the national or international law regimes, which are equipped to deal with these type of issues in a much more sophisticated way. We have an inadequate and uncoordinated approach to cross-border insolvency that are unpredictable and time-consuming in their application, but lack both transparency and the tools necessary to address the disparities and, in some cases, conflicts that may occur between national laws and insolvency regimes. These factors impede the protection of the value of the assets of financially troubled businesses and hamper their rescue. There are 4 reasons of making a law, like the Model Code: access, recognition, relief and assistance, and cooperation. These are the 4 fundamental elements of what is achieved by signing on to the Model Code or incorporating the Model Code into domestic law. What do I mean by access? The provisions give representatives of foreign insolvency proceedings, like in the case of the Dutch trustee, and creditors a right of access to the courts of an enacting state, like India would be the enacting state if it made a domestic law based on model law, to seek assistance and authorize representatives of local proceedings being conducted in the enacting state to seek assistance elsewhere. So your Indian court would be in a position to seek assistance in a US court or a Singapore court. It's important to note that the EU countries are not members of the Model Code of Insolvency for cross-border. So none of the EU countries are effectively reciprocally bound by the Model Code. They are not in the 50 countries which have adopted the code. Fortunately for us, the major trading partners like UK, USA, Japan, Korea are part of that treaty. And the approach of the Model Code also has its limitations. The purpose of the code is also to simplify procedures for recognition, because that's the second pillar. Recognition of qualifying foreign proceedings in order to avoid time-consuming legislation or other processes that often apply. And secondly, to provide certainty with respect to the decision to recognize. These core provisions accord recognition to orders issued by foreign courts commencing qualifying foreign proceedings and appointing the foreign representative of those proceedings, provided, of course, that it satisfied specified requirements. A qualifying foreign proceeding should be recognized as either a main proceeding taking place where the debtor has its center of main interest at the date of commencement of the foreign proceeding, or a non-main proceeding taking place where the debtor has an establishment. That's the kind of case that Netherlands would really pose, that it is not the center of main interest. It is a place of business and establishment that Jet Airways had because it wanted to do business in Europe. Its registered office was not there. The presumption under the Model Code is that the center of main interest is where the registered office is, but that is not necessarily a final presumption. It can be displaced by the actual facts, as if I get the time when I discuss a prominent Singapore case between Singapore and USA. In fact, that was what happened. The third leg, relief. The relief considered necessary for the orderly and fair conduct of cross-border insolvency and the availability of assisting foreign proceedings is part of the four pillars of the model law. By specifying the relief that is available, the model law neither imports the consequences of foreign law into the insolvency regime of the enacting state, nor applies to the foreign proceedings the relief that will be available under the law of the enacting state. Key elements of the relief available include interim relief at the discretion of the court between the making of the application for recognition and the decision of the application, an automatic stay upon recognition of the main proceedings, and relief at the discretion of the court for both main and non-main proceedings follow the recognition. And lastly, cooperation and coordination. These provisions address cooperation among the courts of states where the debtor's assets are located, and coordination of concurrent proceedings concerning the debtor. The model law expressly empowers courts to cooperate in the area governed by the model law and to communicate directly with foreign counterparts. Cooperation between courts and foreign representatives and between representatives both foreign and local is also authorized. The provisions addressing coordination of concurrent proceedings aim to foster decisions that would best achieve the objectives of both proceedings, whether local and foreign proceedings or multiple foreign proceedings. This is the attempt of what the model law of cross-border insolvency attempts to do. Now, what has happened in the context of US and UK? There is what is known as a judicial insolvency network memorandum. This memorandum was prepared in Singapore in 2016 with the cooperation of several countries, and is a guideline for communicating and cooperation between courts in cross-border insolvency matters. So essentially, it lays down the principle of what happens when parallel proceedings are on. There would be a judicial hearing simultaneously between the Indian court and the foreign court by live video or Zoom connectivity. And there would be application of the 10 guidelines which have been prepared by the signatories to this memorandum. There are 14 guidelines. So those 14 guidelines would be applied as a cooperation principle between courts which have entered into and recognized that there would be differences in procedure, and they're trying to assimilate a common procedure between two foreign sovereign entities. There is also procedure which is signed off in this memorandum, which deals with joint hearings. You can have a hearing between a national company law tribunal and an insolvency court as if the insolvency court in a foreign country is the third member of the national company law tribunal. I mean, this is a unique aspect of cross-border insolvency, which has been attempted by this network code. What then happened is that the European Union and the American Association all signed up to this joint procedure. And therefore, today, the advanced nations have a common cohesive procedure which does not create anomalies or which does not create conflicts of judgments, as Mr. Dwarkadas mentioned, but it is done in tandem and with an aim to actually promote a sensible order which results in the augmentation of assets in the estate of the debtor. There is just one case which I'd like to discuss, in relation to cross-border insolvency between Singapore and US, and it has very interesting facts. There was a company by the name of Zeta Jet Private Limited in Singapore, and there was another subsidiary company, a wholly owned subsidiary in USA. The model code had just been brought into force in Singapore by passing it as part of the local law and introducing it into the 10th schedule of the Singapore Companies Act. That has now become an independent law by itself, but it contained the law of cross-border insolvency. And America was already a member of the Treaty of the Model Code on cross-border insolvency. So there was reciprocity, there was an understanding of recognition. Now, there were proceedings which were ongoing in the American courts for Chapter 11 proceedings, which would mean rehabilitation and reconstruction of a corporate entity in financial distress. During the process of this happening under Chapter 11 of the US Bankruptcy Code, two shareholders of the Singapore company and two creditors went to the Singapore court because the registered office of the Zeta Jet Private Limited was in Singapore, and obtained an injunction restraining the US bankruptcy court from proceeding with any rehabilitation matter. The US court, when it got this judgment from Singapore, said, "I am not going to follow this. It doesn't bind me, and I will proceed with my Chapter 11." But as time and circumstances will reveal, this became a case of bankruptcy, and therefore the proceedings moved from Chapter 11 to Chapter 7, and bankruptcy was really ongoing. In order to effectuate a bankruptcy, there was a necessity of the US administrator to come to Singapore and claim that the US law must be made, as US decision must be made as part of the Singapore tribunal's decision. Now, a public interest issue was introduced that the US court had, in defiance of the Singapore court, passed an order, and therefore this is not a case where the Singapore courts should aid and assist a US proceeding because it was violative of the public law of Singapore. But keeping into consideration the Committee of Courts, because they are both common law countries, even if it was not a common law country, under civil law countries also there is procedure available. The court granted a limited recognition of the US authorities because the US trustee was asked to appeal from the judgment of the Singapore court, stating that it should not be, the injunction should be vacated, and therefore the appellate authority, the Court of Appeals in Singapore, should look into it. If there was no recognition given, even the limited right of appeal would not have been available to the US trustee. The US trustee demonstrated before the Singapore tribunal that significant business of Zeta Jet Private Limited was in US, and they factored into locations from which control and directions were administered, location of clients, location of creditors, location of employees, location of operations, location of assets, dealing with third parties. All these issues were considered and presented before the Singapore court, the Singapore Court of Appeals at that point of time. And the Singapore court directed that the order be revised, that the proceedings in US be treated as the COMI, or the center of main interest, and the proceedings in Singapore, which were where there was much less business, be treated as the non-main proceedings. And that's how the proceedings happen. So this is demonstrative of the facts as to how cross-border insolvency really operates. The objective is not to show one's authority of the law. The objective is to implement efficiently and organize the debtors' assets in a manner that they satisfy both sets of creditors, the creditors in US and the creditors in Singapore. Our law, for example, enables a foreign creditor, whether an operational creditor or a secured creditor, to come to India and ask for reliefs under Indian law. So this is something which is a difference between the way our law is administered and the way their laws are posited. So the purpose of explaining this summary decision, or the summary of this decision, was essentially to explain how the process of two separate jurisdictions bound by a treaty is actually implemented. The injunction granted was vacated by consent of parties. It did not need a judicial order. It was by consent they said that this will not apply. And the proceedings went back to the US court, and the US court was the main court, and Singapore actually aided and assisted the main proceedings. So this is the sum and substance of an important and significant case in cross-border insolvency. There are several cases which are there, and they're building up slowly. It's not as if there's a major, among the major new countries, there is not much judicial precedent, but it is evolving. As Tal said, there are many more precedents of UK, but those precedents are at difference with the model code. There is the Gibbs principle, which is not being made applicable throughout other jurisdictions. US doesn't recognize it, Singapore doesn't recognize it. So there are differences between the UK process and the process which has been adopted by countries which are members of the, or adopted the model treaty. Even England is a member of the model code, but this difference persists. I think I'll wind up because I've far exceeded my time, but the only consolation I have is that we started late. Thank you so much. We can't hear you. You're on silent.
Can you hear me now?
Yeah, now you're just put on.
Okay. So I think I was just referring to you that the job is even more difficult after you spoke, because one, of course, you were part of the original legislation, and what you said possibly makes all the sense. So we all started with the first case on cross-border insolvency, which Chanak alluded to. That case, and the company is now about to take off again and fly again, but we are still awaiting our cross-border insolvency law. So that's the time period, and that's the swiftness we need in lawmaking as well, right? We got our, and my topic to what Shaurya told me to talk about is what's happening in India so far as the cross-border insolvency law is concerned. I think both Janak and Mr. Shroff talked about the requirement of enactment of law. We can't just work on ad hocism the way we have been working in this country for many things. But this law definitely requires a legislation. So the first attempt which we made to bring in the legislation was the ILC report, the committee report which came in 2018. And since then, there has been a lot of discussions and debates, but nothing came through, particularly in form of any enactments. Recently in 2021, the committee to bring in the rules, the cross-border insolvency rules or the regulations as they call it, also published a report which again suggests a lot of amendments to the ILC report of 2018 and suggests the way forward so far as cross-border insolvency law is concerned. So at least we have made a couple of attempts since the law, the original IBC law was enacted in 2016, at least in 2018 and now in 2021, we have something to talk about and to debate. So given that short time left in this our panel, I would like to touch upon 2 or 3 aspects of this new law, or the proposed law, which requires due consideration, and maybe based on our experience we can see how it can be implemented. I think the first and the foremost is this whole aspect of reciprocal arrangement. Now, while we have seen adoption of this law even without any reciprocal arrangement, as Chanak was talking about under 234, 235, but at least the law proposes a reciprocal arrangement amongst the unilateral model law country adopted unilateral model law, and it puts an exception that the government will have to enter into either reciprocal arrangements or at least announce the reciprocity available within those countries. Now, I don't know how this would be implemented in a cross-border element where there can be several countries where the assets are or the businesses are, because we just talked about the COMI and the concepts of foreign proceedings and foreign non-proceedings. But at least if I draw some reference from the arbitration law, where this concept is available for enforcement of awards, where almost now 186 or 187 countries are part of the New York Convention, and we have about 50 countries who are notified as the reciprocal arrangement under the New York Convention, as far as India is concerned. So I think the first and the foremost aspect that we will have to deal with this is how are we going to ensure that the hurdles or the roadblocks on this whole concept of reciprocal arrangement, particularly at least in an award or an enforcement regime, there are only 2 countries possibly involved, or maybe 3. But in an insolvency proceedings, there can be many countries involved, considering the nature of business that we are currently in. So I think that's one topic which clearly requires some amount of debate and discussions, and the draft report is up for comments. The second point is again the public policy exception. uh, what if there are 2 different regimes working in 2 different countries with you know uh, concepts of center of uh, main interest? The public policy angle may be very different in 2 different countries, and somewhere we need to align the 2 regimes, and there is a clear exception given that if public policy does not allow to recognize uh, the the judgments or the orders in reference to the reciprocal arrangements or the judgments passed in the countries with reciprocal arrangements, then Indian courts can deny the recognition as well. Now again, public policy from an enforcement of a judgment or an enforcement of an award is very different than public policy in terms of recognition of different proceedings, particularly in an insolvency situation. So again, I feel there has to be some better uh, clarity or an understanding as to how the reciprocity angle and the public policy angle would be covered as part of our proposed law. Otherwise we'll be having possibly another debate only on cross-border insolvency going through the day, once we see some judgments coming through those two aspects. Mr. Shroff also referred to interim reliefs pending the proceedings. Now, this is again, in my view, a big question mark so far as the Indian law or the Indian regime is concerned, because while there are several provisions to look at restructuring at one end and insolvency at the other end, but to provide for interim reliefs beyond the moratorium, which anyways come as part of the law, I don't know how much of that powers are already provided or already be read into the current law, because it's very important to carve out what kind and what measures can be granted when there are two pending proceedings in two different countries and we are still grappling with decisions as to where the commie states and where is the non-main proceedings and where is the main proceedings. So again, in my view, that is going to be a bone of contention as we move forward on this law. The fourth point that when I was reading the law, it may be a small point, but it can lead to a little bit of a conflict going forward. I think on the applicability itself, I think somebody already talked about whether it can be applicable to individuals or not. I think Shaurya spoke, will determine how holistically it can be applied. But beyond that, it also talked about foreign companies, and they say foreign companies for the purpose of this code is different than the foreign companies as we generally understand under the Companies Act. So again, there is a little conflict there, and there are other provisions of winding up of unregistered companies, right? So I think again we need to bring little bit of a clarity to avoid parallel or conflicting proceedings on winding up of unregistered companies versus foreign companies, and how do you define, because that's going to be the biggest starting point. Because when you say yes, a foreign creditor can come to India to take any company to an IBC, but vice versa obviously is not true. But then when we talk about a foreign company in India, how do you define it for the purposes of this act? While there is some guidance, but there is a little bit of an overlap as well, and a conflict as to how it is dealt in the Companies Act. The other aspects of the ILC report and the committee for the rules under the cross-border insolvency is about exclusion of NBFCs, because they have separate rules on the FSP insolvency, and they have clarified that that can be dealt with on a separate note. So I think these were the possible aspects that may require some thought through enactments, rather than coming up with some adoption of just a unilateral model under the Part Z or whatever they call it. I think in my view, unless we get handle on this 4 or 5 aspects, it's going to be very difficult to bring the kind of cooperation and the reliability Mr. Shroff also talked about when there are two different proceedings in two different jurisdictions, but ultimately moving in a common objective. So I'll stop here, I'll pause here, but happy to discuss as things move forward. Thank you.
Okay, thanks, Vapak. I think we have touched upon various subjects, and I know that we still have to have a law on this, and maybe discussions such as this will help us to go forward. And we now have Mrs. Nandini Mishra from the Ministry of Corporate Affairs, who will now enlighten us as to where we are and how do we go forward. Over to you, ma'am.
Yeah. Thank you, Mr. Mandal. I'm really humbled to be amongst all the legal luminaries, and after hearing them, I really do not know if I have anything to add. But I would like to reiterate that the central government is continuously trying to strengthen the IBC code based on market realities and emerging jurisprudence. And as we have already discussed, that we have had 6 amendments, and the latest one being the pre-pact insolvency resolution to give relief to the MSME sector, the hard-pressed MSME sector during the COVID. As regards COVID, the cross-border insolvency provisions, the code has, we have already discussed in detail sections 234 and 235 to deal with cross-border insolvency cases, but it was felt to be severely inadequate. And you are all aware, and it has been reiterated numerous times, that number of committees making their recommendations, starting with the ILC in October 2018, and wherein clause by clause analysis of the model UNCITRAL law was taken, and modifications suiting to the Indian context was made, and they recommended a draft provision on cross-border for insertion in the code. In January 2020, the MCA constituted the cross-border insolvency rules and regulations committee to recommend subordinate legislation for draft provisions of cross-border. They also submitted the report in June 2020. It provided recommendations on draft rules, regulations, notifications, guidelines, and capacity building for cross-border insolvency. It also suggested few modifications to ILC. Government undertook massive public consultations on both ILC and CBIRC report way back in 18 and again in 2021. Cross-border work picked up again after COVID in 2022 when the Union Finance Minister in her para 76 of the budget speech said necessary amendments in the code will be carried out to enhance the efficacy of the resolution process and facilitate cross-border insolvency resolution. So it is now felt that enacting legislative provision on cross-border is essential to address the emerging issues on cross-border. As seen in the recent cases, the introduction of a cross-border insolvency law in the IBC that is in line with the international best practices and suitable for the Indian context in the current changing geopolitical scenario would be beneficial to all stakeholders. To quote Tal, at least that should be the first step. And I'm sure we are all coming up with it soon. How soon, I cannot commit. The draft provisions for cross-border as recommended by ILC and CBIRC after detailed examination of public comments is under consideration, active consideration for enactment. Interministerial consultations are also going on. All I can say is let's hope that it's coming soon. Thank you all so much.
Well, thank you, ma'am. It's encouraging to know that the government is moving ahead, and we will look forward to the legislation coming through soon. I think we have completed all our speakers, and I'm really grateful to all of them for this deep insight into an area of law which is very complicated and very international in perspective. Before I end, we have run out of time, but I have been asked that there's one question from the audience, which I would like to put it to the panel. The question says, is India ready to adopt cross-border insolvency, given the fact that domestic insolvency at times becomes a never-ending saga? Well, that's an interesting question. I don't know who wants to take that.
I don't think it's about readiness. In my view, it's a requirement. I don't think it's adding to anything. It's only completing the current scheme. The businesses that we are grappling with already have the cross-border element. I don't think we can do it one after the other.
May I add to that, please? I don't think it's a question of whether India is ready. India ought to be ready if it wants to be part of a global player. Its doors should be open not only to enable cross-border insolvency reciprocity to take place, and it's basically when you talk of introducing a law or a model law, what it really means is this. This is what our law offers. Are you willing to sit across the table and arrive at a reciprocal agreement with our country? If you don't have a model law in place, you can never talk to the other side. So the question doesn't arise. The question that has been asked is India ready? I mean, without it, there is going to be no reciprocity. That's the answer. Thank you.
Would anyone else on the panel would like to comment on that? Well, if there's no other reactions, I think we will end this session. I'd like to thank all the speakers and the audience for being here. I hope you found this session useful, and that will be all. Thank you very much.
Well, that was an enlightening and an insightful session, and I would like to thank each of you for sparing your precious time and being here with us and sharing your expertise. Thank you so much once again. Well, we will take a very short break, like of 5 minutes, and this is because we are running short of time. And before we do that, we have a very special moment that will be happening right here on the dais, and I would like to call upon Nadia for doing the felicitation to the guests of honor right here. Thank you.
All the speakers joining virtually, your memento of appreciation would be given to you at your respective addresses. Thank you.
Thanks to all our honorable guests here. And now we'll be starting off with a networking break. And you can just take 5 minutes. I would request you all to please take only 5 minutes as we are running short of time and we have so much more happening here. And this entire event is for each one of you. And I request everyone to make the most of it. Thank you. Authorities for the Indian IBC story organized by the Indian Chamber of Commerce. The panel members comprise of Mr. Ravindra Kadam, Senior Advocate, Ms. Farishta Setna, Senior Partner at DMD Advocates, Mr. Rajkumar Bansal, Managing Director and CEO of Edelweiss Asset Reconstruction Company Limited, and Mr. Ankush K. Mehta, Partner at Cyril Amarchand Mangaldas. And the panel will be moderated by Mr. Abhishek Gupta. He's the Associate Partner at MZM Legal LLP. So once again, I would request everyone to please put your hands together for our dear panelists. And thank you so much for being here. Thank you.
Very good evening, ladies and gentlemen. May I begin this session by expressing our heartfelt gratitude to the ICC for organizing this event on various aspects of the IBC. As mentioned by earlier speakers, while the IBC has been one of the most effective economic reforms in this country, it also has its own share of difficulties. Now, in the context of difficulties, perhaps the most unique difficulty faced by this legislation is the ongoing skirmish between investigative agencies, for example, the Enforcement Directorate being the most prominent one, and at times the CBI, and various authorities under the IBC, that is the Resolution Professional and at times the Committee of Creditors. Now, this conflict, this skirmish, brings us to the topic for today's session, which is the role of these investigative agencies in the operation of the IBC. In this context, the uh, current topic of this ongoing skirmish between the agencies and the authorities really was brought to light by by one of the biggest non-performing assets in this country, which is the Bhushan Power and Steel Limited, which is the company known as Bhushan Power and Steel Limited. Now, here we had one of the largest NPAs in the country on the verge of a successful resolution, courtesy almost 20,000 crore bid by JSW, which was on the verge of approval by the consent tribunal. It was in the year 2019, at this opportune moment, when the bid was being accepted, that the Enforcement Directorate swooped in with an order attaching assets worth 4,000 crores of the corporate debtor, which was BPSL. Now, while this dispute itself, that is the measure that the ED took against BPSL, has not met with any successful resolution till date. It did open up the entire dispute surrounding the investigative agencies versus the authorities under the IBC. In this context, Indian jurisprudence has evolved with this dispute, and various tribunals, appellate tribunals, and even the Supreme Court have weighed in on this. So in this context, may I request Mr. Kadam to please share his thoughts on the evolution of the Indian IBC story, the conflict between these agencies and the IBC.
So the JSW bid, which was successful and who resolved the insolvency of Bhushan Power, was the first case where this issue really arose. As one understands, really, since criminal law visits consequences on promoters and directors who are responsible for the so-called proceeds of crime or the money laundering issues, with the promoters and directors, there was never a difficulty. The problem was that you have liability affixed even on a corporate entity. And that corporate entity doesn't, though it may change hands because it comes into the hands of the successful resolution applicant, that entity remains liable. And after the Supreme Court judgments in the early 2010, 11, etc., and the judge judgment also. So the problem was that what happens with the company? Does it continue to be liable? If you interpreted the provisions of the Act, obviously it wouldn't. But there was a lack of clarity and the ED was adamant. Therefore, we then had to have, of course, first the judgments came and eventually amendment came by way of 32A, which seems to have substantially taken care of the problem. So the evolution is from zero or into the general law, into a specific provision, which takes care of it. And hopefully, by reason of all these judgments, Mohan Raj and the Delhi judgment, all those seem to have taken care. And also the Bombay judgment of Shinde in DHFL, which also seems to have taken the same view consistently, that 32A needs to be given full effect. So now that courts are following this, it should be time for the ED and government authorities to wake up and say, okay, we won't pursue this because we are barred by law. The successful resolution applicant shouldn't have to come back to the writ court and get an order quashing the proceedings under PMLA. Now you've got a Bombay judgment, Delhi judgment, Supreme Court judgments upholding the constitutional validity also. So I hope that, the authorities wake up and smell the coffee.
Thank you for sharing your views, sir. May I invite Ms. Sitna to share her views on the same?
Right. In terms of the way we see the scope and ambit of fraud that takes place across the country, across companies that are the subject matter of CIRP, Corporate Insolvency Resolution Process. The one thing that is clear is that our agencies inevitably act when it's rather too late. So when we're talking about the Enforcement Directorate, for instance, very clearly, for them to come in at the last minute and seek to enforce some form of provisional attachment in order to establish that they've done their job is something that we have been seeing forever. We've seen that it is inevitably absolutely inefficacious in all respects. And ultimately, it seems to us that it is almost devised to ensure that all of the wrongdoing is effectively permitted to walk away into the sunset with the promoters intact. And for all intents and purposes, therefore, I don't know if 32A is really the full answer. That is the point that I want to make. I think that this so-called cleansing that happens in the hands of the successful resolution applicant is certainly something that requires revisiting, because what could very well happen is a promoter who has engaged actively in activity which is within the purview of the PMLA and therefore is effectively actionable and is therefore the subject matter of a provisional attachment should certainly continue to remain answerable. It can't simply be that a white knight comes along and effectively all of a sudden those money laundering allegations just fall away into the sunset. I think there's something dramatically wrong with that. And I do believe that there has to be some form of better accountability in order to ensure that the kind of fraudulent activity that currently permeates companies, and obviously we can't be naming them here, but everybody here, I'm sure, is fully cognizant of which companies we're talking about, should not be permitted to go away without any kind of accountability. And in my opinion, there's certainly an increasing requirement for the financial creditors as well to step up, not just the ED. The financial creditors, when they see things going dreadfully awry in the company, must necessarily step up, bring in their forensic audit requirements, ensure that the relevant agencies are enlightened to what is going on in regard to the NPAs and the defaults. Typically, we see the NPA has happened in year X, and within 3 years, because now we have law to the effect of you must bring in action within 3 years, within Section 7, etc. So you will see the bank sauntering in at the last. Now that is something that's so thoroughly unacceptable. And 32A is the full answer. I think there's something fundamentally, radically wrong with it. And while I appreciate the point that Mr. Kadam makes, and obviously that is a legislative fix, but I think it's the wrong fix and somebody needs to take a hard look.
Thank you, ma'am. So your approach actually perhaps lead to a couple of more questions. The first of which I would like to put to Mr. Bansal, because he is, after all, our industry insider on this panel. So that is, what do lenders, ARCs, who are typically investors in the distressed sector, and the current crop of distressed investors, the specialists, feel about this skirmish between the ED on one hand and the RP on the other, and the effect of that on the assets of the corporate debtor?
So I'm not a legal person, just to clarify that. So basically I'll speak from commercial angle. And Madam said something about financial creditors should take action earlier, much earlier. Agree, but it doesn't happen. They have their own constraints. And when you are asking from ARC perspective, I'm including the banks. Because finally ARC are working for the banks. So they are acquiring the debts from banks or NBFC. So their approach is same. Because whatever ARC gets money, finally it goes back to the banking industry or NBFC. Now, the issue is, what is this crime which ED is trying to say? I think the two wings of government, and especially within the same department, ED comes into the same department, by the way, which issued the amendment. Even Section 32A was done with the Ministry of Finance, though MCA issues those amendments, and they were still not agreeable, despite the government and legislator clear intention that we don't want to penalize the CD, the corporate debtor, and Especially if you really see section 32A, it has two conditions. One, the resolution plan should be approved, and two, there should be a management or ownership change. Then only it comes into picture. So the person who is buying it, that should not be penalized. That is the whole idea. But as Mr. Kadam said, the case against the existing promoter, case against his misdeeds or his or her misdeeds will continue. Now, from a banking perspective, let me tell you, most of these projects, what has actually happened is this so-called crime. What has happened? The money was actually of the bank. So from the banking system, the promoter takes out money somewhere else and then brings it back as his equity. 90% cases you will find like that. So it becomes a PMLA case in that sense, because money has come from maybe some overseas center or somewhere, but finally it was money belonging to the bank. So that money only is invested in that project. So bank has to recover, and bank has a right to recover that money. So that was the whole concept. If the money has been invested in the project, whatever it is, whether it is, and hardly it has been proved that it's a crime or not, but what I'm just, and I'm not trying to whitewash those guys, whatever, but what I'm saying is bank has a right to recover that money, and I'm coming only on that point. So if the money has been invested in the company, there is a plant, you can't differentiate. But even today, after 32 years, after amendment of, judgment from the Supreme Court also, still people are not really listening to that way. I recently had a case of PSL, Pune Steel. ED has attached the assets. Despite the resolution plan getting approved, it is in liquidation and all that, but still, and we can't do anything. So we've been waiting already for 4 years. So still we are going to wait for another 2-3 years till we fight up to Supreme Court. So if every case has to, financial creditor has to take up to Supreme Court again after judgment also, this is, I can only say this happens because of whatever reason. But see, finally these ED things, how suddenly this came in Bhushan Power and Steel? It was not there, as I have said, that for so many years. It was not a new thing that suddenly that there's a crime. So I have seen one thing. Many of these cases are got filed, and I'm making this statement from financial creditor side, not from the legal side, please. Filed by the vested interest. It could be RA himself to delay the payment. It could be promoter, which many times triggers is the old promoter, which keeps on delaying. I don't know what pleasure they get, because they get the ego satisfaction that I have not allowed the banking industry to recover money so fast. And I have a number of cases in my ARC in that way. So I think many times I feel these are vested interests who are playing in this filing this ED type attachment. So I will stop at that. Though it has really helped the banking industry that at least today we are clear that asset which is there should not be attached or will not be attached. Thank you.
Thank you, sir. So coming to the second question, while one element of this conflict is related to assets of the CD, the corporate debtor, another element might be the investigation itself, in as much as there are investigations that the resolution professional conducts under section 45 for transaction avoidance, 66 extortionate transactions, and these very transactions also result in punishable offenses which are investigated by the said agencies, the investigative agencies. So in this context, if I may invite Mr. Mehta to weigh in with his thoughts on the interplay between the investigations.
Thank you for the question. I'll answer this question in two parts. One, the role of the ED under the PMLA, and the role of the liquidator or the RP under the IBC. So the question that is put is, what is the conflict? I think in my view, the role of the ED to investigate a criminal offense will necessarily carry on independently of what other IBC proceedings are going on. As far as, in my, again, my considered judgment, in the reading of section 45 and section 66 means that the IBC has been sort of conceptualized to preserve value of an asset. So with this combination and this mix, the liquidator or the RP has given a power that wherever he finds that an asset has been undervalued, he can immediately take this issue up to the adjudicating authority. There are, of course, timelines under 66 which say that If a particular transaction has happened within 1 year, it is questionable. Within 2 years with a related party, it is questionable. So to summarize my answer, I think the conflict as such may not be there. Of course, it will depend on a case-to-case basis, but the ED under the PMLA should have an independent right. Thank you.
Thank you very much. While we have some sense on the possible conflicts, one consensus appears to be that Section 32A, implemented about 3 months after this entire Bhushan Steel saga, Bhushan Power saga, was with the intent, the sole intent of putting this conflict to rest. Now, while we have briefly alluded to it, may I invite Mr. Kadam sir to take us a little deeper into whether 32A actually helps out or not.
See, 32A was intended to ensure that in what the Supreme Court said in SR, that the resolution applicant should get the property on a clean slate. So one Supreme Court said that, and that is the intent even otherwise of 31. It says that it will be binding on all, including government. So it binds the government in all its avatars. It doesn't exclude ED, etc. So that way 31 itself was sufficient. But ED, various different agencies, CBI, so many agencies started prosecuting the company. There are 3 entities. One is the original promoters, directors, the company, and the new resolution applicant who is coming. 32A now protects the second and third, but not the original promoters. So it specifically says that against them the action will continue. So one would have thought that this would have ordinarily resolved the problem. So this is one part. So hopefully, by and large, most courts are now following it. It should end. But the ED says that we have under Section 8 a power to attach assets which are proceeds of crime. Now, court said, what will you do with this attachment? So PMLA was amended to give them a power not only to attach those properties, but to sell them and to distribute the money which they get to various, whoever is entitled as a creditor. So you have 2 mechanisms. One is the PMLA, where the ED is doing the role of recovering the assets and selling it and distributing the proceeds to various creditors. And that's the same thing that the IBC contemplates, that the COC will approve the plan, and then when the sale takes place, the money will be realized and be distributed in accordance with the resolution plan. This conflict is not yet resolved by any courts, though the code, of course, is very clear because it says this is a later statute, 238, etc. Overriding provisions of the IBC should prevail. But this conflict is not resolved by a judgment. And therefore, many attachments do continue. And the ED says that we will do the same thing because that is our power under the PMLA. So assets which should have been released and which they are holding on to, there is money that they'll be entitled to sell and realize. So the RP will have to move the NCLT to stay the ED from selling the assets. So these sort of things really the government should resolve, as he rightly said. I mean, both come under the finance ministry. The government, you had some panelists here from the government. These things should be brought to their notice, and obviously they must be knowing it because the banks and the lenders must be bringing it to their notice. There doesn't seem to be any sense of urgency to resolve this at the government level. Both are wings of the government, both are part of the same ministry. They could have easily resolved it, but this is one major pending issue where you still have attachments by the ED saying that since I will take it to the logical conclusion under my statute, while the IBC says another. IBC obviously prevails, we all as lawyers understand that. But the government has to finally put its foot down, or we'll have a judgment. Till that judgment happens, these problems will continue.
Certainly, sir. Thank you. You had expressed strong reservations about 32A. So if one were to ask you to perhaps challenge the provision in a court, would you like to take us through few of the preliminary grounds that come to your mind?
Well, as I started out by saying earlier, the fact is that this cleansing mechanism that is in place has a fatal flaw. And that flaw has to be addressed. I don't believe that can be addressed by the judiciary. It has to be addressed by the legislature. I do believe that notwithstanding the widest powers that the Supreme Court has, ultimately it has a duty to interpret the legislation. And absent a well-considered legislation, we're going to continue to flounder because you can't really expect the judiciary to continue to evolve solutions that haven't been catered for. The important thing ultimately is that there has to be accountability. You cannot allow for, in the name of successful resolution applicant being insulated, which I'm all for. Certainly, I wouldn't want any surprises if I were declared the successful resolution applicant. So that's not what I'm advocating at all. What I'm saying here is that in order that the criminality, which is the subject matter of the money laundering attachment, which has been levied through the Enforcement Directorate, has to necessarily be kept intact. And it is not enough to say that that proceedings will continue in parallel. The fact is that if the provisional attachment gets vacated on account of the IBC supremacy, then you have effectively rendered the powers of the ED negatory. And that is something that has to be carefully considered, as Mr. Kadam rightly said, by the ministries. They have to allocate how they intend for this conflict, as it were, to get adequately addressed. And to answer your question, I don't really see the court sustaining a challenge on 32A per se. What I'm saying is something far more fundamental. I'm saying find a problem solving mechanism to ensure accountability.
Understood. Which brings us perhaps to a commercial question of if the government were to reconsider and perhaps dilute in some way the effect of 32A, would the industry stakeholders coming back to the ARCs and the investors be affected, which has a sequitur, which is that have they been really helped by 32A? And I would invite Mr. Bansal to share his thoughts on this matter.
I think very true. It has rightly done so, and I'm not going into the criminal aspect of that because, as I said, the earlier promoters are still liable. So, but as far as the lender is concerned, naturally he is looking for it because the money has gone from their system. As the new investor, whosoever is buying this asset, or whether it is a strategic investor like JSW or a financial creditor, suppose if overseas fund invests in a power plant, or naturally they will like to have a clear title to that. If tomorrow after my investment or after fund investment, if there is a doubt whether I will get that asset, so naturally people will not invest. So I think it has improved the investment scenario. This has given a huge comfort to the investors and the buyers of the assets that at least I am getting a clean asset and full asset. There could be one or two cases, outlier, but otherwise most of the cases today, at least the buyer is aware that I am going to get the full plant. I have one case where the ED has attached one small portion of the plant. Now, how do I sell the full plant? It's a big challenge. So, but at least in IBC it is very clear. SurfaceC you can have still that challenge, but IBC I think is very clear. So as far as financial creditor is concerned, it is good for him, good for the banks or NBFC that we are getting full value. For the investor or the buyer or RA is concerned, I think they are getting the full value. As the part of the earlier promoter doing something wrong, that criminal cases can continue. But I don't find even that, I think I was right in saying that that is not happening, but that's a more of I'm not going there. That cleaning of the system, I think government felt by introducing section 29A itself, the cleaning was good enough, that you are getting rid of the promoters and they are losing the companies. I think that part is over, and Ravi was suggesting whether we should relax 29A or whether we should do something else. But I'm just saying, I think that was the intention of the government, and government wanted to give a message which is given in fact. Now slowly people have started asking for relaxation of 29A. And it's not a small thing what government has achieved. In that sense that we have been able to get rid of the huge big promoters from owning those assets. I'm not making a moral statement or anything. I'm just making a simple statement. I think government has achieved that purpose.
Thank you, sir. So while we have considered the legality and perhaps some commercial aspects of 32A, question remains on the operational front, which is if a part of the senior management of the corporate data were to continue post approval of the resolution plan, would any investigations against them, especially by the resolution applicant, be barred by the operation of 32A? May I invite Mr. Mehta to...
Thank you. I think as Mr. Kadam mentioned, 32A was introduced in 2019 and basically didn't stop the liability for corporate data from continuing. Of course, it had certain conditions that would be fulfilled as well. Two cases that come to mind. One is Manish Kumar versus the Union of India of 2021 by the Supreme Court. And the second is Nitin Jain versus the Enforcement Directorate 2021 Delhi High Court. Both these were very clear, one upholding the validity of 32A, especially the second case law of the Delhi High Court, and more specifically paras 983 and 99, categorically mention the doctrine of a clean slate and more importantly say that the investigation will continue and that will not be stopped. So I think that is very important, that while the management may take over or a new management may come in, the right of the previous management to be investigated will not be stopped.
Thank you. Which brings us to the last segment of this discussion. Now, as lawyers, we are trained to interpret laws rather than try and speculate on what they may be. But that is what I have to request our panelists to do, mainly because as recently as April 2020, the Honorable Chief Justice of India had to bear down upon the Advocate General and ask him what is it that the government is doing to resolve this ongoing conflict, because he was hearing the age-old dispute between JSW and Bhushan Power. So that was when he was informed that the ministries, as Mr. Kadam just suggested, should discuss, were in fact discussing. Curiously, both ministries are led by the same minister. Now, I would invite our panelists to assume for a moment that they are in a meeting room with officers of the ministry and share perhaps one or maybe two suggestions that they might have for both ministries into improving the situation or ending this conflict, or at least resolving it to a great extent.
Easy, because the habit of the PMLA, primarily as it was introduced way back, is to punish money laundering. And therefore, it's a punitive and a criminal law. So your criminal law mechanism, which is set out in that act, fair enough, it must proceed and go to a logical end, whether acquittal or conviction. That will be in respect of parties who are responsible for those proceeds of crime, the money laundering, etc. So once, if you stop there with the ED taking charge of the criminal offenses and concluding those whichever way they go, and the IBC, which is a commercial law, which is to value maximize assets which are bought with public money and to ensure that those assets come back into the commercial stream and are useful to society, etc. So that is meant to deal with the assets of the corporate debtor. So the intent of legislature, that's parliament, is very clear. It's just that in the implementation, there has to be a clear-cut line drawn that we'll pursue the erstwhile promoters, take it to the end wherever it goes. So far as the asset is concerned, now the law has been made. Otherwise, as I said, 31 took care of it, but 32A has made it explicit. The asset is out of the ambit once a resolution plan is passed. So you abide by the law which Parliament has made for you. And your ministry has brought that section. So fine, the line is drawn, offences ED, dealing with the assets, IBC. If that clarity of thought is there, which is there in the legislative intent, but in execution it has to be there, and if they do it, there's nothing left there.
Thank you, sir. Ms. Setna, ma'am, if you may share your thoughts on.
In terms of a suggestion to the ministry, I would think that I would ask for more accountability from financial creditors.
Thank you. Mr. Bansal, suggestions, if any?
Anyway, I being a financial creditor, so I don't want to comment that way, but let me put it in a different way. She also said that why the cases are filed very late earlier. I think we need to understand the whole financial system maybe in a detail. This is not the time. But then as a banker, I try first to give a loan in 2-3 years, and I try to keep it standard for 2-3 years. I don't want to make it NPA because the government was not giving me money as a banker. I was in a public sector bank, so let me clarify that. So there was a time when government was not ready to give equity to the banking industry. So what they were doing, so-called what you call is evergreening or whatever. So the interest burden kept on increasing. Then after that only, once it becomes NPA, then I will do the forensic or I will file a fraud case. Why don't we file CBI case? Recently, I think there was a case which was filed after 4-5 years. It went up to Parliament also. Why? Can you tell me any record that CBI has punished the promoters in so many cases, but they have punished the bankers in so many cases? Okay? As a banker, what I will do? Once I file a case of fraud, and I'm not trying to defend that by the way, two things happen. One, I have to make 100% provision. Once I declare it as a fraud, mind it, it requires capital to declare 100% provision. Two, CBI easily hounds only the bankers. The maximum inquiries are done from them. The promoters are most of the time not even aware, not even available to do the inquiries or something. It's typical of 138 section, by the way. Sorry, I'm going there. I have myself filed so many 138 cases as a banker. I always used to go to the court, appear there. The promoter never came. Why? Because if I don't go as a complainant, I can be punished by the court. So it becomes a punishment for the complainant. Same thing happens with CBI in most of the cases. I'm not trying to generalize. The ED also, like what happened in Kingfisher, by the way, just using one name. As Kadam sir said, they attached the assets of Kingfisher, I mean, the holding company, UB holding and all that. And finally that money was realized by them. And finally after the court judgment, the money was paid to the lenders. I mean, they could have done it earlier. Lenders, they could have done directly also. No, they would have saved 5 years. But what happened? Some of my colleagues, some of our bankers got arrested. Unnecessary. The promoter is still enjoying somewhere else. The money ED realized and finally paid to the bankers only. The full loan has been recovered. It's a classical case to understand, by the way. So, coming just to a simple point, the investigative agencies are not doing their work properly. Which cases have been closed by ED? Last 10 years, 20 years, 30 years? At least I have never seen CBI closing any case. So, just blaming financial creditor and expecting accountability, I expect accountability then from judiciary also, from the legal system also, from ED also, from government also. Are we fair? What is the status of in this section 4566 in IBC? Has a single case been decided? Now, you are referring to some preferential transactions. Sorry, I'm slightly going there because I feel bad sometimes after filing cases. 2-3 years cases don't get admitted in IBC and NCLT. Intentionally that period is over. What transaction audit you will do for that period then? 2 years the cases don't get, I have cases which 3 years have not been admitted. Anyway, sorry, I'm just saying, so asking accountability, if you are asking only from financial creditor, please ask from everyone concerned.
Thank you, sir. I think we understand your pain as lawyers, but life, as they say, must go on. Mr. Mehta.
So I'll just make a couple of observations. For example, if you take the Information Technology Act, I'm just digressing slightly, there have been a lot of conversations around amending the act. Just 2 days ago, there was a statement by the Bombay police that they have to amend the act, etc., etc. This is just leading to one point I want to make. I was on a panel a month ago and just wanted to make a statement that there was a very senior, retired, respected police official with the panel. And he said one thing when we were talking about these laws. He said that fortunately or unfortunately, law enforcement is learning along with us. They are not equipped as such to handle most of the complexity of crimes. And why I'm saying this is because today, you open the paper, you read ED has attached something, EOW is involved, CAB is involved. Question is whether their roles are being diluted. Question is whether they are just issuing summons left, right, and center. And one last closing thought, because the PMLA allows the ED to come into action, even there's a presumption of an offense. And that's a very big thing. It's a very wide power that they have. What presumption, what they've applied, no one knows. And then you have to go right up to the courts to, try and get this release. That was the only point.
Thank you, sir. So I think we can conclude reasonably well by saying that 32A doesn't really resolve the problem presented by the dispute between the investigators and the IBC, which apparently creates quite a bit of pain for the industry, like the lenders and ARCs. And perhaps the government is listening in. We have some members from the government and might take some suggestions discussed here to really help out the situation. With that, and a round of applause for my esteemed panelists. May I just request them to address one question, which has come from the audience. I'll read out the question. Does the NCLT step into the shoes of the investigating authority while dealing with avoidance transactions?
No, it doesn't. That's not its role. It's like a court used to have these preferential transactions even under the old Companies Act, which you could apply to the court in liquidation for setting aside preferential. It's the same provision which is now here. There's no investigation there. It's very, very basic. Whatever the liquidator says, now the RP has to say. It's the same provision. There's nothing new there.
Actually, we've seen some applications in that realm, and I must confess that we have wondered how those conclusions ever came about. So I'm sure that's, again, another area that's possibly going to carry all the way to the Supreme Court in terms of what role the NCLT can and cannot ultimately play in regard to evaluating what the RP has filed up in the form of his report saying that these have been avoidance transactions, because clearly there's a lot to be said, I think, on that one.
Thank you, ma'am.
Just wanted to add here one small thing. I think we are not even clear whether NCLT has any criminal powers in that sense. It doesn't have. So that way the investigative agencies have those powers. So I think the role of NCLT is slightly different. In any case, today NCLTs are not capable of doing anything of that sort. So that is a different point. But I'm saying, first of all, let them approve the plans. I'm saying, so they're not capable of that. Even if they start doing the transaction, and they don't have criminal power. So I'm just making that clear.
So it seems that we have done well in terms of time, because of which we get to answer more questions. So from the audience now.
So I just had one question. While 32A stands as it stands today, and let's take it to its logical conclusion in terms of interplay. But there is another debate which I've been seeing in some judgments, that 32A only applies after the approval of resolution plan, and it doesn't apply pending the CIRP proceedings. Is this itself not in conflict? Because if the proceedings are ongoing in parallel for CIRP and the investigations or the attachment can happen, then what are we expecting the resolution applicant to consider it as part of its plan? How does 32A achieve its objective, whatever that objective is? So one debate is what we debated, but question is whether it should apply even pending CIRP or only after CIRP?
The section says that it will be only after the plan is approved.
Yeah.
Therefore, the real issue is, and this it's a good point, because if I'm going to bid for something, I know that the moment my plan is approved, there is no liability to the corporate debtor. And I will, as a new resolution applicant, I will also have no liability. So that's clear in the provision. What you're asking is what happens between the initiation of insolvency and till the plan is approved.
Because the
proceedings continue, that's the problem. So
and
maybe...
the property can be affected by it, right? There can be...
No, but if you look at it the other way around, supposing the plan fails and nothing happens, then what will you do?
I'm just trying to understand this. Sorry to take it a little longer, but if you want to achieve 32A objective the way it is, of whether that should be even applicable during the CIRP.
That because sometimes the CIRP may come to an end, it may be concluded under 12A, and it may go back to the original promoter. So many issues may arise during CIRP. Things are not final. So you want to give a clean chit to the person who takes it afterwards. And then once he takes the company gets absorbed and he has no liability. Till then the liability will be there. What you're asking is what if those proceedings go further under the PMLA during, because now NCLT, though it was required to do it in 180 plus 90, is taking 500 and 600 days to resolve one insolvency. So in the meanwhile, what happens actually, it's very difficult to understand. Moratorium is there, but moratorium does not apply to criminal proceedings. Moratorium, if it applies to criminal proceedings, maybe they might have to amend 14 and cover criminal proceedings in 14 during the CIRP. That might be a solution. But maybe it might be worse than the problem itself. So they have not done it.
I want to just add to that to say that effectively, if the ED proceedings under PMLA do progress to that significant level that they could on account of the delay in the insolvency process or the CIRP process, you could effectively be faced with a situation where the confiscated asset would necessarily have to be carved out. So that's really what, in my opinion, is something that people should be looking hard at. That really was the point that I was trying to make earlier, that firstly, they need to get in earlier, and they need to preserve the asset, which is the subject matter of money laundering, because surely that can't be handed over to the successful resolution applicant, whatever be that asset that is created by virtue of money laundering. That was the point I was trying to make earlier.
Sorry, let me just add slight confusion to that. If I understand your question, ED attaches an asset during CIRP process, right? So after the approval of the plan, in any case, that attachment goes away. So there could be a stage where ED attaches the asset, takes the possession, sells it. That could be one stage during CIRP process itself. But otherwise, if it is not able to sell, which is most likely it will not be able to sell. So it will remain, and it as a plan, it will go through, no? I didn't understand. Criminal part, they can continue with the against the existing promoters, old promoters. Asset will remain. As Kadam sir said, even if ED sells those assets, the money will go to financial creditors, no?
On this, that apart from running the CIRP process, how much time we are spending on dealing with these inquiries, and this is nowhere part of the RP's responsibilities, but we are dealing with multiple authorities who are investigating. Whether that's part of the role or not, I don't know, because your attention is diverted. Instead of trying to resolve the company, you're trying to cater to the loads of inquiries and information feed.
Look at it. So as we up, and I think, should we include it in 14, all these proceedings? Then you'll have promoters under 10 going into insolvency to get the benefit of 14. So I don't think it'll be worse than the disease.
I just have one question to the panel. So how do you clear this visible conflict of law between two agencies of the central government with the war over assets?
Faster insolvency resolution. If your insolvency resolution is expected to be over in 180 days, and then you added 90 days. So it was expected that in 180 plus 90 it would get over. If it does get over in that 270 days, which is 9 months, I don't think ED will have any issues and it won't come. There won't be a conflict. So the thing is eventually being more efficient, having better and more efficient disposal mechanism in the NCLT. As they initially did. In the first 2 years, it worked well, as all things do.
Just one question. May I? This is in relation to personal guarantor. When it comes to a personal guarantor, NCLT directly initiates the insolvency. They don't go into so much of detail, but there are companies who has borrowed money, and the number one, the compliances are not proper, and secondly, there are a lot of money transactions which are not in place. The books of accounts are not proper. So is there any room, or if you could throw some light to safeguard the interest of personal guarantor? Because there are personal guarantors who are very innocent and laymen as well, and they really, in the business, they don't see any conclusions, but that a sudden thought comes up that the company is into CRP. So any room of thought, if you could throw some light on this, would be.
I give a practical position. Today, DRT is supposed to take the case of personal guarantor if the case is not filed in IBC as a CD. DRT has not declared any rules, so not even a single case has been filed in DRT for personal guarantor. The only personal guarantor in this country who have paid the money sometime are the guarantor to a housing loan to a friend or to your relative. Otherwise, I have never seen any recovery from personal guarantor to corporate debtors. Okay? So you should not be worried if you are given a guarantee to corporate debtor. But you should be worried if you are given a personal guarantee to a home loan.
Thank you so much.
We have a very eminent panel here and legal experts. Mr. Bansal, you made a comment earlier about delays in admission of IBC cases. So just wanted to hear the views of experts here that there's talk about automatic admission going on right now, and with very minimal judicial intervention, cases could be admitted. At least you start the process. What's your view on that? Is that principles of natural justice would apply there, or is this going to ever come into play? Swift admission.
Courts have already, if you see section 7, it's almost automatic as it reads. But courts have interpreted it to mean that no, you must have natural justice, you must give them an opportunity to respond, etc. So that will never go. That's part of what you call the basic structure. Otherwise, your law will be contrary to the basic structure of the Constitution.
Right now, they're just talking about this data based on IU, just with that data, and there's a default established.
Information utility data will be conclusive. The section also says so, no? But it's still you're giving them an opportunity of dealing with it.
Judicial member, please take only the maybe some technical members, no, both. Or a banker.
But that will be a problem, no? If you have both technical members, they'll only look at the technical point of view. Who gives justice? Who decides that whether...
IBC doesn't require justice, sorry.
Then there are
IBC
judgments.
Act is not supposed to give justice. Sorry, I think this is a separate discussion. I'm not going there. COC decides that, and COC is supreme as per Supreme Court decision. I think the NCLT members are not supposed to sit on judgment, but they will not. It will never happen. Okay.
Thank you, sir. Thank you. Thank you to my panelists. Thank you to the audience. And I think this brings us to the close of this session. Thank you so much.
Hello. Thank you so much for enlightening us with your insightful knowledge. Thanks once again. And I request Nadia to please be on the dais to felicitate our guest.
Thank you all the speakers. As a token of appreciation, ICC is planting 10 trees per speaker, giving back to the earth. So I would just like to hand over a small token of appreciation to all of you for being present.
This is to all the panelists. It was lovely having you with us. Thank you.
Sir, can I check your audio, please? Can you say hello, hi, anything? Nasser, Nasser.
Well, the time is here to join the fireside chat as thought leaders and subject matter experts discuss the theme A Red Devils unfolding the Jet Airways insolvency in the Indian IBC story organized by the Indian Chamber of Commerce. Our notable speakers for this session is comprised of Mr. Rajesh Narayan Gupta, Managing Partner of SNG and Partners, and Mr. Ashish Chuacharya, Partner and Head of Restructuring Services at Grant Thornton Bharat LLP. So I request our dear guests to please be on the dais. And as I welcome them on the dais, I request all the dear guests to please put your hands together for them.
Hello. So good evening, friends. I am glad that after these fiery sessions, we have a short storytelling session. So we have Ashish here to share his experiences on Jet Airways. But before that, I may just say that as a banking lawyer, I've always seen banking evolve. So I know there are challenges. The members here before me mentioned about those challenges also. But I remember that when I joined the profession in 1988, and when the banker asked us in how many days the money under the suit would be recovered, I could only look at the sky because there was no answer. It could take 5, 10, 20 years, God knows. So the only provision then was a provision under the Code of Civil Procedure to file a suit for recovery or to go for a summary suit. That was the only provision you had. 1988, Section 138 came with the Negotiable Instruments Act. Dishonor of check was made an offense, and there was some added advantage which the bankers got. Then we got SARFAESI, we got DRT Act, we then got IBC, we got RERA also, which has a bearing on the banking system. So therefore, if you see that a lot of laws evolved over a period of time insofar as banking sector is concerned, the legislature and judiciary both came forward to support the banking system as a whole. There are challenges, but the good news is that there are ways and means by which these challenges are being met also and being addressed as well. So when I first spoke to Ashish on this session, Ashish, of course, said that 30 minutes and the whole of Jet Airways, we thought elephant in the room, but now we may just say elephant in the jar. So we have to just put it somehow in this 30 minutes. Although we did hear about the cross-border insolvency in the previous sessions, which have some bearing and which will make perhaps the life of Ashish difficult for one or two questions.
But still, before we go forward, may I just request Ashish to share his experiences on Jet Airways. Let us hear his story. Why don't we just hear a story from him? How this whole saga unfolded, and what are his learnings, what are the challenges, and how ultimately this was successfully achieved. Over to Ashish.
Thank you, Rajesh. And as you said, 30 minutes to cover 3 years is next to impossible. And but I will try my best to bring out the key highlights and just give you a little storyboard of how this started. In fact, probably this is the first time I'm speaking about this in any public forum in a chamber event, because the process was running till very recently. We still are in the process of handover. So there are certain provisions, certain things which I cannot discuss about right now in public forum, but absolutely will give you a certain perspective of how this went about. So let me paint you a little picture. 17th of June 2019, the bank decided that all the efforts that they were making to revive Jet Airways, which had been suspended, the operation suspended in April of 2019, and there were a lot of efforts with State Bank, led by the chairman himself. They had made tremendous efforts. I'm aware of the efforts that they were making to try and revive this, and despite all the criticism which the banks were getting at the time, but they made tremendous effort to not let it go to insolvency. Because insolvency of an airline, that too after suspension of operations, is quite a unique challenge. Never in the history of aviation has any airline which has been grounded has ever been taken to skies again. So people knew this, and idea was to avoid insolvency. But unfortunately, it didn't happen. 17th of June, the filing was made by State Bank of India. I was proposed as the IRP. And going by the history of NCLT, I was not really expecting this to happen anytime soon, right? 20th of June, I got a call from the lawyer that it's preserved for announcement today. And in the evening, the order was issued, insolvency admitted, IRP take charge of the company. I had no clue. I had no clue what to do. As we entered the company next morning, the AOC, or the air operator's license, was suspended. No operations in the company, no cash. And these are things which I learned subsequently, and you'll understand why. There were 10 lakh passenger tickets which were impacted. All the directors and all the KMPs, the CEO, CFO, CIO, company secretary, CHRO, everyone had deserted, resigned, and left the company. There were 14,000 disgruntled employees left deserted, not been paid for 6 months. The company's IT service providers had locked out the company from the entire IT systems, including financial information. We were dark. We were in a dark room. We had no access to information, no data. And 7 employee unions affiliated, 3 of them affiliated to political parties, as you can imagine, in the company, who immediately wanted to first come and meet me. And there were 84 bank accounts across 26 banks, including 13 overseas banks. All this we learned over the next few days, because day one, obviously, we didn't know the size and scale of what was going on. So that just gives you a little overview of how this process started. And I think in terms of size of this insolvency, I've been a resolution professional now for 5 years. I've handled, probably in terms of debt, much larger cases than this. This was not the largest in terms of size of debt, or but the complications in this case, and this was a B2C company, right? One of the first companies which has a B2C. Before this, it was largely the manufacturing hard assets companies, right? But in India, apart from the telecom case, which was well publicized, this kind of high-touch industry, there had been hardly any. So there was quite a start to the process. The claims process started. Uh, as a regular process, we had set out the advertisement, Form A, and all of that. And suddenly the claims started pouring in. We had 21,000 claimants with 44,000 crores of claims received value-wise, of which finally we admitted about 15,500 crores. The sheer numbers were overwhelming, and the issue more with that was, the public, the Joe public on that, who's bought a ticket and who wants a refund, they don't care. They don't understand IBC. They don't understand moratorium. They want the money. You promised me money. Now you are in charge. You owe me. The guy who's a loader at the airport, he doesn't understand IBC. You can't teach him IBC. A financial creditor is a sophisticated creditor, or even some of the large suppliers are sophisticated, right? You can talk to them with reason. Here you can't talk to them with reason, right? We were locked in the office. We were locked out of office. So yeah, it was. Just to give you a perspective, the claims that we received were from 26 different currencies across the world. So it was quite overwhelming, to be fair. I must say, I give all credit to my team. We had a great set of advisors, our legal advisors who were helping us. The way we started handling this was a bottom-up approach to see what issues need urgent attention, because didn't want to make the situation erupt into something bigger, right? Because we had pretty aggrieved, people. So the way we decided on managing that is we had a separate task force on communication. So dealing with, and this was no official like PR agency or something, right? Because they won't be able to come. This is not a PR exercise. This was literally crisis management. So we had a team of experts who were dealing with the employees and those issues, and ticket owners, basically passengers who were aggrieved. We had multiple communications through various medias, social media, press statements, FAQs, because to give you an example, for a passenger who has bought a ticket, let's say from a travel agent, right? We were getting 3 claims for each such passenger. Passenger writing to us, the travel agent writing to us, and then IATA, who's the clearing agency, them submitting a claim to us. And not providing details, so we set out formats. We had regular communication with these guys just to make them understand, or try to make them understand the process. We cannot file their claims. They had to do it. But that whole process was, I would say, at one point, I remember I had about 30 people working only on the claims management of this. Okay. And even today, 1 year after the plan has been approved, I still get claims where passengers still are aggrieved that they have not submitted the claim, they don't understand IBC, they want the money back. So we still have those things. In terms of other challenges, I would, what comes to mind is the unique nature of this business, right? These are aviation assets. These are not, by now, I think, running a steel plant is left hand, with no disrespect, but that's something which is pretty streamlined, that's process driven. This was a sector there was not much experience in. The aviation assets preservation requires pretty technical skills, because they have to be preserved, maintained with certain protocols which is defined by the OEM. So we contacted Airbus, we contacted Boeing to get the manuals updated to make sure that we can preserve these. Otherwise, they become a piece of metal. The aircrafts will become a piece of metal. We still had, so there were 124 aircrafts which Jet Airways was flying at its peak. When it went down in April, there were still about 100 odd aircrafts in possession. So the model of the industry is largely, I think it was mentioned earlier, maybe not in this same context, but there was 100, it's mainly leased assets. But Jet Airways, other than Air India, was the only airline that I'm aware of in India which actually had owned aircrafts as well on finance lease. And there was a finance lease where out of 120 installments over 10 years, 2 installments were left. Company had paid 98% of the installment, but 2 installments were left, but the title would never pass. You know, like a hire purchase car, you don't leave one installment, they can repossess. So we had, the aircraft lessors who were coming after our own aircrafts, but there were 100 other aircrafts which were on operating lease. So they were being repossessed by the lessors, and you could do nothing about that because that's not an asset of the company. That they were literally on an operating lease. But we still had about 10 or 12 aircrafts which needed to be maintained. India has got no aircraft or aviation technical agencies or to maintain, every major repair. I would even say less than major repair, our assets have to go out of India, Singapore, Turkey, UK, to the MRO. It's repaired and comes back. Repaired or overall, there's a schedule for that. We had our assets all over the world. They don't follow IBC. We had negotiations with them. We retrieved certain assets to maximize value for the process. But all of this required a lot of, thinking on the feet because this was not something, there's no textbook, there's no manual to follow. I think the operational challenges in this, insolvency was something quite unique, what we managed to achieve. And I've not even finished, talking about some of the international and legal issues. I can go on and on, but just to highlight a few, we had 2 international insolvencies going on. I think one was discussed at length earlier, the Dutch process, but what was not mentioned as well, there was another insolvency liquidation proceeding in UK, which was on. There was a Bangladesh High Court order on seizing our funds lying in the Bangladesh account, not an immaterial amount, because Jet Airways had a substantial operations to Bangladesh. So we had a lot of cash sitting in the account there, which we still haven't got, by the way. We had, I'm just trying to think, I just tried to jot down some of the points which, in terms of, I mentioned earlier about the investigations and authorities. Within the first month after starting, we had SFIO, ED, sending me notices and making visits, asking for all the information which even I didn't have sight of at that time. Yeah, I mean, I can go on and on, but yeah, those were the that was the scenario of when this insolvency started. And then of course, COVID, March 20. So we had 3 rounds of EOIs where we had at least 4 or 5 bidders in every round, but not a single plan. And why we didn't have a single plan? I mean, there could be many reasons, of course, but one of the key reasons was there was no commitment from the government that the key asset, which are the slots, the flying slots that at the airports, that would be made available. Right. So they wanted a guarantee from the government. We even, in fact, I remember the honorable bench at Mumbai NCLT actually impleaded directed the Ministry of Civil Aviation to come to court and to give their view, because I made a statement to the bench that, without this, we cannot proceed. We need to know what's going to happen. They called them to the court. The Joint Secretary herself appeared in the court, Mumbai NCLT pre-COVID, just before COVID. And she said that we'll make our best efforts to cooperate and to give, but we cannot give anything in confirmation. And the judge actually, beyond that, they couldn't do much. They said, please try and support. This is a case of national importance. These are the words actually recorded in the order as well, that to revive Jet Airways. So yeah, that was the sort of scenario. From there, we've come a long way. COVID happened, 4th round of EOI. We managed, again, we got 4 bidders, and we got 2 resolution plans this time. And so people said, in COVID time, it must have been really difficult. How did we manage that? Actually, to my mind, actually, COVID was probably a blessing in disguise for this case I'm talking about, especially, and just for in context of Jet Airways, because suddenly, the entire sector was down on its knees, right? So there's no big gap. The aviation sector was entirely in shambles all over. So people probably just saw some value in getting something which is uh, possibly clean, will not have carryover liabilities and stuff. So yeah, I mean, that's how we managed two plans. And finally, one of it was approved by 99.2% majority.
Yes, that was fantastic. Yeah. So, Sai, we heard Mr. Shroff, we heard Janak Bhai in that fiery chat when this cross-border insolvency precedents, which were Jet Airways and Videocon, were totally demolished, whatever the NCLT or NCLAT felt about it. So, it may be good to hear from you that supposing the NCLT or NCLAT had decided not to go the way they went, which probably Janak Bhai also said was not proper. If that was not done the way it was done, then what impact would have made on Jet Airways? But what difference did it make actually?
Sure. With all due respect to Janak Bhai and Mr. Shroff, while their criticism from the legal aspect was fully justified, and I completely understand where they're coming from, but I don't think they are aware about what was happening in the company, what was happening there. So
Therefore, we want to know behind the scenes story. What exactly,
So while the NCLT and by the initial application made by the Dutch trustee had called it, void and in nullity ab initio, I think that was a bit of a hurried call that probably should not have been looked at in that manner. But had we not got NCLT to nudge us or push us towards getting into this protocol, I think there would have been a destruction of value. We had one large wide-bodied aircraft, fully operational. This was actually, I happened to, visit there a couple of times. I actually went inside that aircraft 2 or 3 months after the insolvency started. That aircraft was ready to fly. It had all, I know you fly long haul, you see all those pillows and the sheet that they give you on every chair. It was all ready. In fact, in the lock, the liquor cabinet in an aircraft is always locked till the time they take off. So they still had that. So it was ready to fly. The passengers were boarding. And the bailiff took possession of that aircraft at that time not because of, I think that was erroneously mentioned earlier that it was due to some financial creditor filing. It was actually one of the ground handling agencies who was handling the Jet Airways operations in Netherlands. They filed and they got immediately a bailiff order, and there was a bailiff in possession of that. It was not even the Dutch trustee who was in possession of the aircraft. So by getting into this protocol, what we managed to achieve is a great cooperation between the Dutch trustee, recognizing his laws, their laws, and them equally appreciating our, laws. Komi was India, of course, but if this was not done, if this was a contentious proceeding, we certainly would have lost anything to do with that asset, and neither would they have gained, mind you, because again, it's a very unique business. This large aircraft which we see flying out there is nothing but a piece of metal without the what we call the back to birth documents. The history of that aircraft in terms of its maintenance history, anything that has been put into that aircraft, taken out of the aircraft, how it has been repaired, where it was repaired, is part of a back to birth documents. And these are called dirty fingerprints. So there are a lot of physical documents that are to be there. So typically, so these aircrafts are about 11 years old at that time. For an 11-year-old aircraft of this nature, we have about 80 to 90 boxes of documents which are mandatory for any. So if anyone has to buy that aircraft, they need to see those documents and verify those documents being available. Otherwise, they don't give value. Otherwise, it's junk. So they would have probably been able to sell it as, so there are, like our Raddiwalas, there are Raddiwalas who will buy aircrafts to part it, and they will sell parts of it, that too without those documents. So there are such agencies as well that do it, but that would have yielded probably, less than a third of the value what we finally managed to get. So finally this aircraft was sold under the cooperation protocol, where both of us were part of the negotiations, and and the value for the Indian creditors was protected by me. At the same time, recognizing that the Dutch trustees has responsibility towards under his law, which was all achieved because we had this cooperation protocol. I tell you, we lucked out as well a bit. That's why I mentioned to, I think, someone earlier that had we some framework, some guidelines, it would have been probably easier. I think the relationship we struck as individuals, as institutions, recognizing each other's compulsions, I think that kind of helped. But we can't guarantee that happening in all situations, right? So I think it was extremely important. However, from a legal standpoint, it may not have held good or anything, but I think having that cross-border protocol is something which helped add value to the creditors in India.
This is very insightful because as lawyers, we see how the law is interpreted, but maybe there are things which happen behind the scene which may be useful in this kind of resolution process. So Ashish, as you know, you see a lot of lawyers here, a lot of young lawyers as well, and IRPs as well. So we might take benefit of your presence on the dais to ask you one thing, that when such matters are referred to you, not only JET, but other matters also, how do you look at these matters? What are the 5 or 6 big things you would like to keep in mind before you handle any project, which could be great learning for everybody sitting here as well?
Oh, I think there's a lot of experience
Still,
in the room. There's a lot of experience in the room. I don't want to preach.
Good to know from you how you look at a project.
So Rajesh, in my view, when we look at any insolvency, I think typically insolvency professional, I think, has a very thankless job, number one. But he wears multiple hats. One is to run the statutory process of follow the code. All the eyes of the regulator are on you. You have to follow all the timelines, the documentation, run a claims process. So that's one part of the role of the RP. The second, of course, being find a resolution, find a buyer, find someone to take the company forward. So never take the eye off the ball that what's the objective. So we typically divide ourselves into 3 teams. One is looking at the statutory compliances part of it, claims management, reporting to regulators, communication. Second is the resolution piece. So prepare a good information memorandum. As much data as you can give, the better value you can get. And then third is running the operations of the company, right? Because if you can't keep the company as a going concern, even the code lays it out, right? That it's one of the duties is to try and maintain as a going concern. Don't try anything fancy. Don't try to, say that I will improve the operations by X or Y percentage. Don't let it fall. Don't let it deteriorate. But the challenges were, funding. Often you'll find, as soon as insolvency starts, there's no funding available, right? Interim finance is still a distant dream here in India. I mean, though we have managed it in a couple of our cases, but by and large, interim finance is still not so easily available. Though I don't know why, because it's a super priority available under law, but that whole industry is still evolving. So run the operations of the company, manage the cash flows, and then you have to another aspect. Then of course all these authorities, investigations, avoidance transactions. That's another part which one needs to do because there's immense focus now of the authorities on this area. So I would say that look at the key stakeholders. I mean, if you have a large employee base, I think communication is extremely important. How you communicate, the empathy. See, the biggest problem is there's no money, right? That's why the company is where it is, right? So if you can empathize with the stakeholders and give them, uh, be patient hearing, explain to them what this process is, what you're trying to achieve, probably, you'll get their support. So in Jet Airways, I mentioned about, these 14,000 employees who were impacted. When we started the insolvency, there were still 8,700 employees on the rolls of the company. But there was no one there to help you. The top two layers had gone, right? The directors had gone, the CA has gone. So we then had second and third layer. So we just formed this concept. I think it's probably being replicated now in some of the other places, is an asset preservation team. We carved out people from each department, from the second and third tier, who I basically enlisted to take support for running the process. Took them into confidence, explained to them whole process, what we are trying to achieve, how we'll achieve this, what are the timelines. And then, I was lucky to get their support. And we were trying to pay them. No one would work for free, right? So we were trying to pay them better at a discount, sort of reduced pay on special contracts. So there's so many things, one will have to.
So friends, I know we are racing against the time, but still I may just ask one or two more questions before we wind up. One is, we know that most of the businesses in India are family-run businesses. We also know that families run the businesses on their own way, handling the tax, handling the regulators, handling the employees and everything. So most of the businesses are family-run. Now suddenly a situation comes when these businesses are being taken away through the IBC process. Now IRP, who may be a qualified person like you, and may not be an industrialist or a businessman by profession, suddenly they are put in the seat of this businessman or the industrialist to take control of the whole thing, which is not easy. I always wondered how an IRP would be running different industries. You yourself mentioned that now you handle the aviation part. Tomorrow it may be a steel. Thereafter it may be a chemical. There could be a B2C or a B2B. The different verticals could be there. So is it extremely difficult, or when professionally you look into it, then there are ways and means to address this anomaly? Because as outsiders, we always feel how IRP handles different kind of industries.
So, okay, so I think one is, probably it comes with years of experience and losing hair, that, you realize that 80% of the concept, or any business, 80% is common. See, I've been a consultant advisor now for almost 25 years. I've been doing this. It is the top 15, 20% differential, probably not even 15%, is what matters from industry to industry. The basic concepts of business will remain the same. Your procure to pay, your bill to collect, your employees, handling employees, the compliances. That's a fairly common thread across businesses. That 15% extra, which is unique to that business, is what you need to bridge. And for that, multiple approaches one has to follow. Of course, if you have personal experience of working in that sector as an advisor, as a consultant, that helps. Someone in the team, or you hire experts, because there are experts available on hire, but those experts are not people who can run that process for you. But there are experts. So if there's a power sector, I remember recently we resolved another case, it's public information. So SR Power MP, which we handed over to Adani Group recently, we hired someone who was specifically on coal procurement, because this is a unique part of the business, right? In terms of, how do you price it? What are the calorific values and all that? I'm a chartered accountant. I'm an insolvency professional. I will not know all of that. So we hire experts who are allied to you, and then work with the company's people. I think we tend to shadow the company personnel, and through communication, if we can enlist their support, there's no one better. As far as promoters are concerned, again, there's a mixed experience. There are promoters who want to see their companies prosper. They still want to make an effort till the very end, right? No one's going to run the company down just because, companies have gone into insolvency. 29A is there, but there's also 12A hope, right? People are still trying till the end. So more often than not, I have found that even promoters of businesses have help, but you have to take it with a pinch of salt and be careful that you're not, getting yourself into a trap somewhere. So that's something which you have to be careful of. But if you deal with the company's senior employees and use the promoter to bounce off things, because a lot of the key relationships are with them. As you said, it's a promoter company. So in a running operation, the key vendor relationships, the key customer relationships, they are typically driven by them. So treat them well, talk to them, be transparent. That's all I can say. I mean, that's been our experience at least.
Thanks. So again, the business, there are several verticals we have, like aviation being one of them. So far IBC process is concerned, there are some thoughts at times we keep on listening from several people that why don't we have separate set of rules for different industries? For example, aviation is a super specialized industry. So under the IBC process, do you think we need special rules for different industries, or that is too difficult and is not required actually?
In my view, I don't think special rules are required because that would just complicate things too much. And anyway, this code, if you see, the code itself is actually quite a small, one of the smallest acts in India, I would say. Yep. It's more like it's a very good guideline, right? It gives you the direction of where you need to go. Then it's a commercial law, right? So for an aviation sector, no one taught us to do this, or when we started steel work or thermal power or metals, recycling, no one tells you that you can't define every aspect. So I think one will have to adapt and learn on the go, but you adapt it to a situation. So that's where I think for insolvency professionals, my piece of advice would be that work in a team. It is not the job of an individual. In fact, very recently, finally, I think the regulator is starting to appreciate that, and they're considering whether they should allow appointments of firms rather than only individuals. I mean, we have over 3,500 registered insolvency professionals as individuals who feel that they should be entitled to take up. I mean, yes, there are small cases which maybe the debt size is low, operations are not there or very small. It's not a job of a single person. I mean, I can tell you, without my team, I'm just sitting here because my team is, I know, working there right behind me and they're supporting me. It's not my job. I'm just here to represent them.
Thanks, we appreciate that, and if you're acknowledging them, it's also a good feeling. So friends, thank you. We are over exceeded by 5 minutes only. So I think all of you can, or some of you who are interested, can catch Ashish at cocktail or dinner. We'll just wind up. Thank you very much.
Thank you so much. I would like to invite Nadia on the dais, please, for the felicitation of our honorable guest. It was an immense honor to have you here with us. Thank you. All right, so now let's begin the meet with the seasoned subject experts and thought leaders for the plenary session 3, Protection of MSMEs, aim to safeguard the medium and small businesses in India for the Indian IBC story organized by the ICC. The panel members comprises of Mr. Pramod Nair, Senior Advocate, Mr. Nitish Jain, Partner at Trilegal, Shri Vidyasagar Visam Sethi, Nominated Member, Governing Council of MSME and Director of Saga Asia Group, Mr. Satya Prasad, Senior Consultant at Fox Mandal Solicitors and Advocates, and the panel will be moderated by Mr. Sumit Nankani, Counsel and Advocate at High Court of Bombay. Everyone, please put your hands together for our dear panelists. Dear panelists, it is our honor to have you here with us. Thank you so much for being a part of today's event.
Good evening, ladies and gentlemen, and welcome to plenary session 3 of the Indian IBC story. At the outset, I must convey my sincere gratitude to all of you for continuing to hold on to your seats on a Friday evening. But in a lighter vein, I'm going to venture to assure you that the best has been saved for the last. This session's topic, protection of MSMEs, aimed to safeguard the medium and small businesses in India, is indeed an important one. It is also an evolving one in that the protection of MSMEs has not only been, but also continues to be recognized by our legislators and regulators as being crucial for our overall economic growth and stability. Whilst MSMEs have undeniably witnessed turbulent times in the recent past, there has been some reprieve to the sector in the form of various stimulus packages and exemptions. Whether or not these have been effective, both on ground and in law, forms the crux of this session. Ladies and gentlemen, with these prefatory comments, let me now turn to introducing our panel. Mr. Satya Prasad, Senior Consultant and Head of Corporate Compliance at Fox Mandal and Associates. Satya is an expert who dons 3 hats, that of a lawyer, a company secretary, and last but not the least, an insolvency professional. He has over 15 years of expertise in corporate compliance, M&As, legal due diligence, restructuring, and insolvency. We then have Mr. V. Vidyasagar, Director of the Governing Council of MSME, Saga Asia Group. Mr. Vidyasagar comes with rich experience in the MSME sector. Having founded Saga Asia in 2010, his astute leadership and long-range vision has led Saga Asia to become one of India's largest integrated manufacturing facilities with complete supply chain control. He is also the president of the Telangana chapter of Lagu Udyog Bharati, which is an all-India registered organization of MSMEs, through which he actively partakes in MSME-related policy-making discourses and vociferously advocates for the protection of MSMEs. We welcome you, sir. We then have Mr. Pramod Nair, Senior Advocate, who has joined us from Bengaluru via VC. In addition to being a renowned senior advocate and regularly appearing before the Supreme Court and various high courts across the country, Pramod is also admitted as a solicitor in England and Wales. He is a dispute resolution specialist, having extensive experience in public international law, international trade law, commercial litigation, and arbitrations. Pramod has represented the Republic of India in arbitrations commenced under bilateral investment treaties and has also represented India at the United Nations. Last but not the least, we have Mr. Nitesh Jain, partner at Trilegal. Nitesh has over 15 years of experience in practice areas such as court litigation, international and domestic commercial arbitration, white-collar crime, and insolvency. He has advised and successfully represented a wide range of clients, including large national conglomerates, banking and financial institutions, in a wide range of domestic and cross-border commercial disputes. It is indeed our privilege to have each one of them sharing their valuable insights here with us tonight. So without further ado, let me kickstart this session by inviting our first speaker, Mr. Satya Prasad, to give us an overview of MSMEs and share his insights on their economic significance, their statutory status, and the impact of COVID-19 on the sector. Over to you, Satya.
I promise I'll make it short, and I promise I will make it interesting too. My task is to talk upon who are MSMEs and what are their economic significance. Also, whether the COVID has impacted. And more importantly, IBC, whether IBC protects MSME. While doing so, I will touch upon the two areas. One is IBC protecting MSMEs as corporate debtor, where MSME itself is into insolvency. And also the second part is that as a creditor, operational creditor, whether IBC protects operational creditor. So firstly, yeah. So these are all the topics which we will cover quickly. The first is who are MSMEs. Basically, we have got a notification from the Ministry of MSMEs defining who are MSMEs. There are classifications given based on the investment in plant and machinery and also the criteria on the turnover. Now we all know what is the investment and also the turnover criteria. But importantly, the point here is investment, how it is reckoned. The Ministry of MSME is clearly mentioned that the investment would be typically based on the income tax returns what we file. So nowhere else we need to look at what. And the question comes, if the MSME is a new entity which is incorporated, how is that going to be reckoned? So that is reckoned only by a self-declaration. So Ministry is going to believe what is going to be declared, and they will be regarded as the specific, whether it is micro or medium or small enterprise. The term plant and machinery, investment in plant and machinery, when we say what is plant and machinery, how do you reckon? It is again based on the Income Tax Act. The definition given under the Income Tax Act about the plant and machinery is the same which is adopted by the MSMED Act. Now, whether depreciation has to be calculated to determine the MSME status, the act is clear, depreciation should not be calculated because it's only the investment which is to be looked at. So depreciation has to be ignored. Last but not the least, what is turnover? MSMED Act is clear, turnover excludes the exports. Sorry if I'm missing the slides. Okay. In the interest of time, I'll just go through without the PPT. So what is the economic significance now of the MSMEs in India? Almost all finance ministers in the world, when they are giving budget speech, they mention MSMEs are the backbone of their economy. It's not different from India also. And it says that 30% of the Indian GDP is from the MSMEs. And as per the annual report of 2020-21 of the Ministry of MSME, it is going to be up to 50% in the next 5 years. MSME sector contributes about 40% of the exports of the country. And MSME sector employs 11 crore people in the country. And as per again the annual report of MSME Ministry, it will add 5 crores more. So it would be 16 crore employees in the next 5 years. So that is the significance of the MSME sector. However, this sector had got into a lot of difficulties into the COVID situation what we had. And according to the SIDBI survey, which ministry has presented to the Lok Sabha in the year 2022, in this year, in the February, 67% of MSMEs were temporarily shut for 3 months. And 50% of MSMEs has declined more than 25% of their revenues. And 66% of the MSMEs whom they surveyed, I'm talking about 1029 MSMEs which they surveyed, has declined in profitability for 2020-21. And 65% of MSMEs they surveyed has availed benefits of emergency credit line guarantee scheme. So that's the distress which MSME has gone into because of COVID. Further, the Federation of Indian Micro and Small Enterprises has reported 25,000 MSMEs are yet to receive money from the stressed enterprises which are into IBC. So one side, there are corporate, the MSMEs are turning into corporate debtors under IBC. On the other side, MSMEs has to receive money as creditors. Their money is stuck and the account says 25,000 MSMEs are waiting for that money in the IBC. Now, what are the safeguards? Does IBC really provide safeguards to corporate debtors? MSMEs as corporate debtors. First, we will talk about corporate debtors, then we will go into the creditors, operational creditors. So MSMEs as corporate debtors, which I mean is that the MSME is into liquidation. If it provides, then as after the COVID struck, the basic default amount has been increased by the government from 1 lakh rupees to 1 crore. How did it help MSMEs? MSMEs didn't had cash to pay the debts, so it eventually will default. So eventually IBCs will come in. So 1 lakh, if it is raised to 1 crore, there are less number of cases IBC which MSMEs are going to face. So that is one benefit which the legislation IBC has made. Second is, as we all know, we discussed 29A, that the promoters, managerial personnel, and the guarantors of the MSMEs are now eligible to bid and participate in the resolution process, which is not available for entities other than MSMEs. The third most important safeguard of IBC and MSME is the pre-packed insolvency process, which my colleagues would talk in detail. But basically, they will have a benefit of moratorium with the management retained with the MSME promoters, and it will all complete within 90 days. So with a resolution plan before they go to NCLT. So these are the benefits which are given to the corporate debtor, which is MSME. But if we talk about the operational creditor, MSME has to receive money, whether they have any respite in IBC. Firstly, there is no say for operational creditors, as we know in the COC, so they have no voting rights. Secondly, they are guaranteed minimum to the liquidation value in CRP process. So of course they may get more, but they are going to, they have no settlement amount which can happen. It's only the liquidation value is the minimum. And more importantly, if the liquidation happens, they'll stand at a last priority. And so MSMEs as operational creditors may or may not get anything because of the waterfall mechanism which is prescribed. So after the secured creditor, after the financial creditors, the operational creditors don't get anything. The last but not the least, as far as operational creditor is concerned, is MSME has to receive money from an entity, and resolution professional is appointed, and MSME will go and ask resolution professional that, look, I am an MSME, I need to get within 45 days as per the MSMED Act. Please pay me within 45 days. And MSME Act asks you to pay. Because there is a non-obstinate clause under section 16 of MSMED Act, which says notwithstanding to any other law, the MSME has to be paid within 45 days. Now what happens? The resolution professional will show section 238 of the IBC, which again has a non-obstinate clause, which says notwithstanding to any other act, IBC prevails. So which one will prevail? So there are a lot of case laws. A set of case laws says the special act would prevail, and here interestingly both are special laws. MSME Act is special law and IBC is a special law. There is again finally one set of case laws which says the later legislation would prevail because the legislator, while legislating the later law, knows that the earlier law provided for 45 days. So here in this case, MSMED Act is 2006, whereas IBC is 2016. So IBC would definitely prevail, and they will not be able to enforce non-obstinate clause. So here, as a creditors, there is no respite in IBC for the MSMEs. Why is it so? Is the law not right in doing so? What I feel is the objective of IBC is to resolve the insolvency, not a process for recovery. Therefore, it's because it's not a process of recovery, the creditors' interests are not looked into on priority. The corporate debtor, if the MSME is a corporate debtor, they will be their interest would be regarded first. So these are the basic provisions and safeguards as far as the IBC is concerned for MSMEs if they are corporate debtors and the creditors. Thank you so much.
Thanks very much, Satya, for setting out the foundation of all things related to MSMEs. Let me now turn to Mr. Vidyasagar to get your views on the on-ground situation insofar as MSMEs are concerned.
Thank you, Sumit. Good evening, ladies and gentlemen. Yeah, we all knew, every time, we all knew that MSMEs have been backbone of any economy. It's engine for the growth. But honestly, it took a COVID to realize that MSMEs are so important. The definitions have been tweaked. Like, 50 crores was the limit for investment, 250 crores for revenue. Just to bring Indian industry to global scenario, we always try to ape China. China has definitely taught us that MSMEs have been very important. West has invested in China for the last 40 years. And government definitely acted very quickly during COVID with the GE sales and other things, but not all banks. Not all banks. I'm sorry, yes, there is, we discussed about IBC in the earlier sessions and then how banks had burned their hands. But banks, all the banks did not really come to the rescue of units. Having been president of Telangana Laghu Udyog Bharti, which is India's largest organization in the service of micro and small units, government, though RBI and Government of India has given directives to banks and institutions and NBFCs also, but not all have come to the rescue of MSMEs. Having said that, there has to be a lot of trust and faith between bankers and MSMEs. And then I keep telling that gone are the days where we find willful defaulters in micro and small units. So what has happened in the last 2 years is not enough. We need to take this for a long-term sustainable growth. A lot of ambiguity is there. My friend Satya has been telling about the investment of 50 crores. There's an ambiguity of whether dyes and molds are included in that, electrification is included in that. A lot of ambiguity is there. So it's definitely India is at a pole position now. India is going towards a manufacturing hub, but there's a long way to go, and then we need clarity on many things.
Thank you for your views, Mr. Vidyasagar. Let me now turn to Pramod to get a practitioner's perspective on the various statutory recognitions pursuant to 2018 that MSMEs have been conferred with. Over to you, Pramod, to give us your insights.
Thanks, Sumit, and it's a real pleasure to be with all of you, albeit virtually today. I'm very grateful to the organizers for putting together such an excellent program. As Sumit mentioned, I'll be very briefly dealing with the interplay between sections 29A and section 240A of the IBC. As many of you will know, by an amendment in 2018, section 240A was introduced into the IBC to carve out an exception to the applicability of the code to MSMEs. What the provision did was that it enabled the central government to direct that the provisions of the code or certain specified provisions of the code would not apply to MSMEs or would apply to MSMEs with certain modifications as could be specified in a notification. This change was essentially brought about on account of the recommendations of the Injeti Srinivas committee in 2018. And as far as MSMEs are concerned, the committee had made a number of recommendations. I'll just capture what those, a few of those recommendations. One recommendation was to exempt MSMEs from the application of Section 29A of the Code. Many of you will know that Section 29A was introduced in the IBC by means of an amendment in 2017 to check attempts by defaulting promoters of insolvent companies to essentially regain control of the company by forcing creditors to take massive haircuts. The legislative intention behind that amendment was that promoters could not really be allowed to run a company to the ground, get it to default on its debts, have it declared insolvent, and then come back through the insolvency resolution process to take control once again over the same company and then operate it on a clean slate on a debt-free basis. This rationale still holds good as a rule, but it was considered appropriate that an exception be made for MSMEs. And this was because, unlike other large undertakings which may attract a number of bidders in the corporate resolution process, the actual experience was that as far as MSMEs were concerned, there was often very little interest amongst bidders to take over a struggling MSME through the insolvency resolution process. And if there were no bids during the resolution process, then a productive MSME would have to be liquidated. This would not be good for the economy, and a number of workers would also lose their jobs. So therefore, for this exception, there is a sound economic rationale which requires MSMEs to be exempted from the rigors of the IBC and especially from Section 29A. This has also been recognized by the courts. The Supreme Court of India, in its recent decision in Swiss Ribbons, recognized the importance of adding MSME-friendly provisions in the code, and it found that there was a sound basis for exempting MSMEs under Section 29A of the code. The Supreme Court, in that case, took note of the economic reality that the business of an MSME would only attract interest from a promoter, possibly of another MSME, and may not be of interest to other resolution applicants. Therefore, if MSMEs were not exempted from applying during the resolution process, then other resolution applicants may not come forward, and it would lead to a liquidation of the MSME instead of resolution. This was taken one step forward by the NCLT in the Lakeland Chemicals case, which many of you will be aware of. And in this case, the insolvency application was admitted in March 2019. And just mark this date because the corporate debtor was only entitled to be classified as an MSME more than 1 year later, in July 2020, by an RBI notification, which has just been referred to by my co-panelist. Despite the fact that the entity was only entitled to be classified as an MSME in July 2020, 1 year after the insolvency application was admitted, the NCLT still considered it appropriate to allow the original promoters of the company to submit an insolvency resolution plan and participate in the insolvency resolution process. So now the position is that unlike any other companies, promoters of insolvent MSMEs would be entitled to bid for their companies, and there is no embargo in doing so, thanks to Section 240A of the IBC. So hopefully with the introduction of these exemptions, it is hoped that troubled MSME companies would have additional opportunities to get back to a position of some financial stability and strength. And overall, the national economy broadly and employment generation in particular would benefit as a result. I think so far so good. What we should, however, be wary of is a tendency to give any preference to the promoter of an MSME in the resolution process, or to say that no bids at all are required, as seems to have been suggested in a recent NCLT decision. That, in my opinion, would be going too far and provide a perverse incentive to promoters to run their company to the ground, go through the insolvency resolution process and start off on a clean slate all over again. And that will mean that the creditors of the MSME would be penalized in the process by having to take deep haircuts. So we need to strike a balance there. That's really been the experience of the interplay between Section 29A and 240A. So since I'm the one who's probably standing between you and an appetizing dinner, I think I should stop with that. Thank you once again, Sumit.
Thanks very much for the enlightening insights, Pramod. And we wish you were here to join us for the appetizing dinner. But anyways, moving on from one positive amendment, namely the 2018 amendment, to a more recent one, which is the 2021 amendment. And let me bring Nitesh to comment on the 2021 amendment, which, as you all would have heard repeatedly by now, contains several salutary insertions from an MSME standpoint, particularly this PIRP acronym, which Nitesh will expound on. So over to you, Nitesh.
Thank you, Sumit. Last day of the week, last session in the last speaker. So I'll be very brief. I find this topic of pre-pack insolvency really fascinating. And if this actually becomes successful as a concept, I think it can be a game changer for the entire IBC. Forget about the MSMEs. And I'm sure we all understand what the concept is, right? Pre-pack is that you have your own insolvency plan, the corporate debtor is involved, the shareholders of the corporate debtor, which is around the special majority, the COC, you all come, you all have your own plan, and you go to NCLT that please approve this. It gets approved, it's 60 days plus 30 days, 90 days, and the IBC is over. So it's a very short IBC process. Unlike the corporate insolvency where you have various resolution applicants, and we all have faced, what happens in the NCLT, there are delays, there are appeals and everything. But this is, the concept which is, the PIRP. So under the IBC, from section 50A onwards, there are various sections which explains how this concept can work, right? And there are, according to me, there are enough checks and balances in terms of how the IBC has incorporated the amendments. So it's not that every corporate data, because under MSMEs, of course, there is a 29A exception to the promoter can also apply for this concept. The downside, the way I see this, is because the corporate data only includes the company and the partnership, and majority of the MSMEs are sole proprietor, right? So obviously they don't get benefit of this concept. The checks and balances is that the corporate debtor should not be undergoing any corporate insolvency process. There should not be any liquidation. Is eligible to submit a 29A plan. The financial creditors should have approved by 66% voting in value, right? And then the majority of the directors and the partners, they have to give various declaration that there is no fraud and the other things, right? And then you have the special resolution which is passed by the shareholders of the corporate debtor. So once everything is and this all happens before you go and file the application before the NCLT. So this is all out of court, out of NCLT. The creditors, the corporate debtor, the resolution applicant, in terms of the base plan, you all sit together and discuss. Once everything is there, you go and get a stamp from the NCLT. I'll straight away come to what are the benefits of this pre-pack insolvency process, right? The ongoing management continues, because the limit as far as pre-pack is concerned is from 10 lakhs to 1 crore. That's the maximum for now. I think this is how it's being tested. According to me, it should happen to 10 crores soon, and maybe if it becomes successful, it can go higher also. The best advantage is because the ongoing management continues. So therefore, the promoters, the directors, they continue to run the MSME, right? Which is in the, so that's in the interest of the corporate debtor, which is unlike the CIRP, because you have moratorium, the IRP comes in, the management is taken over, so you don't know what's happening then, right? It's a very informal process, and it's a very collaborative process. The way I explain is that the creditors, the shareholders, the corporate debtor, they all act together in terms of, and to achieve the base plan. Now, so why is that if the corporate debtor and the creditors can discuss and have a plan, why is that you need to have this IBC process? You can always do it outside. There is June 7th circular. There are other mechanisms. The advantage of this is because you get the NCLT stamp, right? So once you get a judicial stamp, then, the apprehension of either the creditors or the corporate debtor or the other stakeholders, they are sure that because you have the judicial stamp, there'll be no more challenges, right? Once you have the judicial order, That's the most advantage. It's the quickest under the IBC so far, right? Because within 60 plus 30, and there won't be any challenges. Because as far as the base plans are concerned, there are certain checks and balances. The base plan also contemplates that all the operational creditors should be paid 100% of their dues. Like the other CIRP process, the operational creditors can be paid, let's say 10% or 20% or no payment or above 1 lakh. There are various criteria, but as far as the pre-pack is concerned, the corporate debtor will have to, first of all, give a list on his own, and they will have to ensure that there is 100% payment that's given. So obviously, therefore, so there are no challenges as far as this entire base plan is concerned. It's a very cost-effective process, obviously, because it's all happening outside court already, and it's the plan that's coming for the judicial approval. And since there are no challenges, there is no, legal cost and that fight that is involved. What is the advantage as far as the NCLT is concerned? Because NCLT, nowadays they are fully packed with various challenges, appeals, several rounds and everything. And as far as this is concerned, because it's already a pre-pack that's coming before the NCLT, it's a simplicitous stamp that's to be put, and therefore it happens quickly. Now, are there any disadvantages? Of course, we keep talking about advantages. What is the disadvantage? Is this a disadvantage that the management of the corporate debtor is continuing? It's unheard of that the corporate debtor is unable to pay the debt. It's coming up with its own plan and asking the COC to please approve this, and it still continues in the management, right? So it is a sort of a, well-defined, not a fraud, but well-defined mechanism of, just to get over the debt that you can't pay. But that's the essence of MSME, right? That's the essence of the MSME, and that's the essence of this pre-pack. We may say that this is a disadvantage, but I don't see that as a disadvantage, because there are various checks and balances. There is a concept of IRP also. There are various provisions and the powers given to the IRP in terms of monitoring this entire process, in terms of monitoring the management. And if the IRP actually finds some problem, it can always communicate that to COC, and it has powers to take that, so that the PIRP can actually fall, right? What is that can be suggested to make this better? And that's my last point. Is that right now it's the cap is 1 crore, the way I explained, but I think if this can be increased to 10 crore and maybe 100 crore, because now the MSME, the total value is 250 crore, right? There's a debate whether when it's been taken to 250 crore, whether MSME will still have the benefit of 29A, right? The exemption, sorry, under the 29A. So the corporate debtor can still present a plan where the total value is still 250 crore. So when then that can go to 250 crore, then I think certainly a pre-pack can certainly go from 1 crore to 10 crore and maybe more. Thank you.
Thanks very much, Nitesh. I'd now like to open the floor to questions. And before I do that, I've already received one. So let me first address this question to our panel, and then we'll take questions from the floor. The question is, do you think that the increase in the threshold of applications to the NCLT under Section 9 primarily has affected MSMEs more in terms of their claims, since MSMEs being service-oriented remain unpaid? Satya, you can lead and everything.
So as we discussed, insolvency bankruptcy code is not a law for recovery of money. So the focus is not on creditors for recovering money. It is on helping the companies which are suffering from insolvency to get them some resolution plan. So if it is recovery, then this is not the law which we should look at. So increasing from 1 lakh to 10 crores definitely is not to be treated as disadvantages. Yes, it is in practice, but it's not the objective of the act to look at.
Pramod, would you like to comment?
Yeah, I completely agree with that. I mean, it's not a recovery mechanism. And if the MSME creditor really wants to commence enforcement action, in addition to the court option and the arbitration option, assuming that there's one in the contract, there is also recourse available under the MSME Act itself. And the fact that there's a very attractive rate of interest that would be available, that would have to be awarded, in fact, to an MSME entity, would make that a far more advantageous proposition for an MSME entity in terms of a recovery action. So, I completely agree that the purpose of the IBC is not to essentially provide a recovery mechanism. There are far more effective recovery mechanisms available, especially for MSMEs, and the MSME Act is a fantastic legislation which provides some very, very beneficial provisions for MSMEs.
Thank you.
Thanks, Amit. I have two questions. First question is, is anyone really aware statistically how many cases have actually gone through this pre-pack route so far and where they are in the process? And second is more to Nitesh. You mentioned about so many advantages of this process and sounds very logically right, but to the best of my knowledge, it's the actual sort of proof of that we have not been able to see yet, right? So what is the reason for that? Why aren't there cases, many cases going through it?
So, I mean, I did look for precedents on pre-pack. I saw one where it was actually contested because the related party creditors, right, they were allowed to vote, which is not, which is what was challenged, and it went till NCLAT, and then NCLAT said that, yes, of course, it can't be done. I found couple of other cases which was simpliciter, where they just simply they filed the base plan and the application, but still under consideration. So it's not that it's not been acted upon. So there are few cases, but I mean, I actually thought there'll be many.
Considering it came in April 21, right? I mean, the PRIP came in 2021 April.
Maybe the awareness, I'm not sure if people are actually aware about this conspiracy, because you have to see who's the audience as far as this pre-pack is concerned, right? It's the corporate debtor, which means the company in partnership, which is between 10 lakhs to 1 crore. That's the limited audience, right? So I think unless there is more awareness about this, I don't think people, because the advantages, the advantages are huge as far as this concept is concerned.
I would completely agree, and the only way to now probably do is increase the threshold. That's the only way you'll be able to see more cases. Otherwise,
exactly.
It'll never get proven this particular section.
Yeah.
If I would try to answer your question, you may also, because you are RP and you have a lot of experience. See, the Act, I'll ask you here to go to this route, prepackaged route, by paying the full amount to the operational creditors.
I was just going to come to that.
Full amount to the operational creditors. So as MSME, I have to pay, when I have to pay full amount to the operational creditors, who is going to be having a haircut is financial creditors who has to vote for it.
Financial creditors will not vote. They will not vote because I have spoken to a few bankers. Said, operational creditor, government, everyone will get 100%. We'll take the haircut. Who will do, and why should we go around with that?
Probably only one thing can possible in the plan is that a deferred payment of 100% is possible to operational creditor, but a deferred payment over a period of time, that scheme may float through. But plain vanilla, I don't think financial creditor would agree.
That's what I feel as well. I agree with you that the financial creditors would be loath to make a decision there.
But ultimately, you'll have to see the nature of the corporate debtor, which is the MSME, right? So we can't generalize this, the view of the COC, the banks, because the corporate debtor over here is MSME. So you have to think about the interests of the MSMEs. But I think this process will still take some time in terms of banks understanding that who's the ultimate predator over here.
Thank you.
The mic is also saying time up.
Last question, I promise. So do you think that the interference of the NCLT in the pre-pack is a lot, in the sense that you have to go with the application for pre-pack, first get an approval, then you have to go back again to the NCLT to get the resolution in the pre-pack approved. So it takes away from the essence of a quicker mechanism to resolve, and it could have been much more like how the RBI circular is, which is completely different in resolution of a stressed asset. And I think that the interference is going to be a hindrance in a time-bound process and a faster process. What are your views on that?
So, I mean, the precedents that I saw is, and the way the pre-pack functions is that the corporate debtor, COC, the shareholders, members of the corporate debtor, everybody, you work on a plan and then you go and ultimately present it to the NCLT, right? So I think the scope of interference of NCLT is very, very minimal in this case. And it's not twice, it's only once that the NCLT will have to approve this, right? So once it's admitted, then of course, and the way the time frame is fixed as far as this case is concerned, it's 90 plus 30, right? If COC has already approved a base plan, they know what the future plan should be. I mean, my guess is because the corporate debtors are allowed to present the plan as far as the MSMEs are concerned, right? Most of the base plan the resolution applicant will be the promoters themselves, right? So I think that may help to, expedite this entire process. But I think the interference will be less because most of your claims as far as the creditors are concerned or the operational creditors are concerned, so those are already taken care of. So I think the interference should be, I mean, it will be minimal, but it is to be tested for sure.
Thank you.
So just to add on, court is granting moratorium, okay, when you're making application. So it will definitely look into and have to, look into the plan, because otherwise if MSME and the financial creditors want to do this, they can do as an outside settlement, right? But they are going to NCLT because moratorium they are getting, as my colleague said, they are getting chapa of the court, right? So a lot of advantages are there and involvement of NCLT is required. So we cannot call it as, too much involvement, but when you're gaining something, you have to go through the process.
I think that rounds up this fruitful and engaging discussion on all things related to the MSMEs and that sector. It remains for me to thank my esteemed panelists, the organizers of today's event for having put together such a wonderful and insightful event. And with that, I would, of course, the participation, without whom there would hardly be any purpose of being here. Thank you very much, one and all.
And thank you, Sumit, for moderating this. Thank you.
It was an absolute honor to have you on the dais, and we have actually received some great insights into the topic, so thank you so much. And to give you a token of appreciation, I would request Nadia to please come on the dais and show our gratitude for the love and support that you have shown for the event.
So as a token of appreciation for each speaker, we are going to plant 10 trees. And thank you for this insightful session and being patient for being the last panel today without any objection to that.
Ladies and gentlemen, we have finally come towards the end of today's session. Before I close this event, I would like to invite Mr. Ratish on the dais to give the closing remark to all of us. Thank you.
To begin with, I'm really sorry that the whole event got delayed. There are certain things which are not in our control, but then I believe you guys had really good fun and you had all the insights that you really looked for. And I think I'd like to appreciate the patience of all the speakers and the attendees over here and online as well. Special thanks to all the sponsors, MZM Legal, we have SNG Partners, and Grant Thornton and Saga Asia Group. Special thanks to Nadia for curating this whole session. It was a great, very insightful session. Thanks a lot for the support. And with this, I'd like to call it an end, and please do enjoy the dinner and the cocktails that we laid out for you. Thanks a lot.
Thank you so much, Ratish. And with this, we close today's event. I extend my gratitude and I thank each one of you for the great time that we had with you all. And we would love to see you soon again. With this, I, Miss Angela Gill, your host for today's evening, would come to an end. Thank you.